right, let's proceed. Yes, good morning.
Good morning, Attorney Michelle Mencken. I represent the defendant appellant Michael Robertson. A decade ago or so, we were hearing of instances of people hiding cameras in bathrooms, changing rooms, tanning salons, and engaging in peeping Tom activity via hidden camera rather than through the blinds of bedroom windows. And legislatures across the nation responded with video voyeurism statutes. In 2004, Massachusetts enacted Chapter 272, Section 105, and like many similar statutes enacted around that time, Section 105 punishes secret surveillance of a person who is nude or partially nude while that person is in a place and circumstance with an expectation of privacy. Now, the Commonwealth now wants to use Section 105 to address a newer phenomenon of upskirting, that is, using a cell phone camera to take a picture up the skirt of a person out in public. And that's not fair. Section 105 doesn't prohibit that kind of conduct.
Are you saying there's no expectation of privacy?
The requisite expectation of privacy is absent out in public. The expectation of privacy that's required is that the person be in a place and a circumstance where they have an expectation of privacy. Now, the Commonwealth argues...
Yes, but it's expectation of privacy in being so photographed. So that means being photographed up one's skirt, doesn't it?
Well, I think that it means, if you read the language of the statute, so photographed would refer back to the manner that has just been described earlier in the sentence, and that is secretly, without consent, while the person is nude or partially nude.
So I guess that's my question. Isn't that really where this turns on, what nude or partially nude means?
It's one of the key factors. I would argue that there are others, but I do take the position that the person has to be in an exposed state, in a state of nudity. The Commonwealth urges that it's only the image that needs to display nudity. That's contrary to the language of the statute. The Commonwealth argues that a person has the requisite expectation of privacy is satisfied because a person expects that the area under their clothing is private and protected against hostile intrusion. And maybe that's so, but if a clothed person is out in public and reveals areas under their clothing, whether inadvertently or otherwise, to plain view, she or he no longer has an expectation of privacy in that which she has exposed.
I'm having trouble figuring out here, are we talking only about those instances where the camera can capture something that the naked eye cannot? I mean, if you're sitting on the tee and someone is very scantily dressed, and just by sitting there you can see something that would otherwise be in an intimate area, but you don't. And you photograph it, is that different than the situation of what I take upskirting to be would be that the camera would be able to discern the area of intimacy that you would not otherwise be able to see. Is that right? Am I getting something wrong here?
Well, there's a factual distinction. I'll point out that in this case, there's no allegation or charge that the defendant captured an image or tried to capture an image of anything that wasn't visible. These two women wasn't otherwise visible to somebody sitting at a particular vantage. These women were in skirts and seated on the MBTA.
Not standing on
a platform. There was no allegation that he reached anything under, or had a hidden camera, or a shoe camera, or a mirror, or anything of this sort.
So the allegation is the same as what you could see.
As what you could see. And if it weren't, even if it weren't, if this were a case where somebody had reached under or used a mirror or something like this, or been able to capture a vantage that wasn't visible couldn't be foreseen by the person, by the subject of the photograph, I would still argue that that's not covered by this statute. because the person is still not nude, and that's a requirement of the statute.
You don't dispute that there was secret surveillance.
Well, I actually would suggest that this is not secret in the manner that's contemplated by the statute. The use of a cell phone out in public is not the kind of clandestine recording. For example, this was actually addressed in the wiretapping cases. Glick v. Cuniff in the First Circuit, for example, said that the use of a cell phone openly didn't violate the statute.
Was this openly done?
Well, there was an allegation that the defendant may have acted furtively, but it also was stated in the allegations that people could see that he was holding his cell phone this way. Witnesses observed the image that was being recorded on the cell phone. The police saw him using the cell phone in this manner. So, there's no suggestion that he said, hey, look at this, I'm going to take a picture of this, and sort of openly said this, but at the same time, it's not secretive in the manner that a camera hidden in a smoke detector or behind a mirror is secretive and clandestine.
Well, here the intent, though, is whether he's hiding, and at least according to the allegation, as I recall it, it wasn't that he was just it was holding it by his side and turning it in a way that could capture, as though he were just standing there with a cell phone in his hand. That's the allegation. So
that's the allegation.
But more importantly, maybe, are we focusing? Well, let me let you finish.
So back, I think, to Justice Link's question, if you're seated on the train and you have exposed areas of your body, I think even the Commonwealth concedes that what you've exposed is open to plain view, and you lack an expectation of privacy in that. For example, the Commonwealth refers to one of the pictures that's in the record appendix of the gentleman on the train whose buttocks are exposed, and an onlooker has taken a picture of this and posted it on the web. And the Commonwealth concedes that the exposure there, even if it was inadvertent, it's not protected by an expectation of privacy that society recognizes as reasonable.
Is there any difference between what might be exposed to the eye as opposed to what's exposed to a camera, someone taking a picture of it for having a permanent image of it?
Perhaps. It's not addressed in this statute. This is an issue that the legislature may wish to address. They haven't done so. And it's not this court's prerogative to read these new interpretations and nuances into a statute that wasn't drafted with that intent. I would also point out that if it is offensive to somehow sneak a camera up under a hidden area of clothing, that is offensive no matter where you are. And then the question arises why the legislature would have a requirement that a person be in a place with an expectation of privacy if that was what was intended to be covered. It becomes a superfluous word.
Well, I mean, this statute was passed, I guess, at the nascent stage of cell phones. Perhaps before people understood that they could have this other purpose. But does the fact that the legislature did not anticipate this mean that it would not necessarily apply? I mean, Commonwealth, I'm sure, will argue that regardless whether the legislature anticipated this particular use, the language nonetheless covers it to the extent that it is truly upskirting. I mean, you're describing something which is not upskirting, and I guess the record isn't clear whether this is truly upskirting, but I understand upskirting to mean putting the camera in a place below the skirt so it's looking up at a place where the eyes would not otherwise see.
Well, I think it's important whether the citizenry and law enforcement and the judiciary can discern from the statute that this language clearly covers the situation that you've described. Nudity is a concept that's readily understood. You have to be in a state where you're exposed. The scenario that you're describing is not clearly covered by the language of this statute that requires that you be in a place as well as a circumstance where you have an expectation of privacy and that you be nude or partially nude. So expanding, reading the language, massaging the language to fit this scenario creates a variety of problems, vagueness, which I've just touched on, and also overbreadth. Imagine that a woman is breastfeeding in public, and somebody who is morally opposed to breastfeeding in public, or a journalist who is aware that this is an interesting issue, wants to capture a picture of this. And the woman maybe has a shawl draped or something to try to maintain some level of modesty, but the onlooker is alarmed at the immodesty or the potential immodesty and captures an image from a vantage where breast is exposed in order to document what they perceive as a problem. Now, that person, under the Commonwealth's reading of the statute, would be guilty of violating Section 105, and that's clearly protected conduct.
But I guess I'm concerned not so much with this statute, but with your view that the reasonable expectation of privacy would not include upskirting, because I can imagine an example of paparazzi seeking to upskirt celebrities and then managing to put somewhere those photographs, and the claim there would be that would be an invasion of privacy.
Well,
would you agree it would be an invasion of privacy?
I agree that an invasion of privacy, that in the invasion of privacy tort context, the expectation of privacy certainly can extend to the areas under one's clothing. I think that expectation of privacy has been defined in a certain way, has been limited in a certain way by the language of this statute. And so this particular statute doesn't provide that. This particular statute provides protection to people who are in places that are suitable for undressing when they're in a state of undress.
So if, maybe this goes to the maybe the vagueness. So if the photograph that the person took, the defendant or putative defendant took, upskirting, was of someone who the underwear covered any part of the body that fits within the definition of partially nude, that would not be a crime, right? So it really depends on what kind of underwear the person has on? I mean, is that your argument, that you can't enforce that?
I think that when you interpret the statute the way the Commonwealth does, you do get into situations where you have to question what sort of underwear was the person wearing. Did they take reasonable precautions to cross their legs on the tee? And it becomes a very dicey sort of prosecution. And it seems, frankly, absurd to me that the statute would provide protection to people who were wearing a thong or no underpants, where somebody who was wearing underpants wouldn't be protected because they're not in a state of nudity where somebody in a thong may be. If it's an invasion of privacy to upskirt, it should not matter what's exposed under the skirt. So I just want to address the Commonwealth. Getting back to that, the Commonwealth does talk about that it shouldn't really matter whether the person is actually nude under, because in this case, for example, the defendant is only charged with an attempt. And that notion would be that he hoped to capture an image of partial nudity, but was foiled in that attempt by the unforeseeable eventuality that the woman was actually wearing underpants. And this also, to me, yields an absurd result, because the majority of people are going to be properly attired on the train and are going to be covered. And if anybody who's taking a picture of somebody on the tee can be supposed to have hoped that the blouse would gape or the shorts would gape, anybody could be convicted of attempt under the scenario that the...
So if we agree with you, what's the rule of the holding in the case going forward? Can people then just pull out their smartphones and take pictures wherever they are?
I think that this would be a case, like many others, Rahim is one that's cited in my brief, where the court can suggest to the legislature to take a look at this statute, there is, as I've pointed out, proposed legislation pending in both the House and the Senate before the Judiciary Committee right now that is an attempt to address upskirting. It specifically covers surveillance of the intimate areas, and they talk about naked or undergarment-clad genitals. And I suggest that this court could suggest to the legislature that it address this issue, since this statute does not.
Thank you, Counsel.
Thank you.
Good morning. May it please the court. Kaylin Campbell on behalf of the Commonwealth.
Other states have amended their statutes to be explicit on this point. Why isn't that the right course here?
Your Honor, I don't think it's the right course here, specifically as it relates to the defendant's argument, and I would point the court towards the proposed legislation, which, while it does change substantively the statute to include intimate areas, it does not change the place and circumstance language. So looking at the legislature, even if it's considering changing it, which it is, it's considering it changing it to only change the area of the body that's photographed.
In this case, is it the Commonwealth's position that because the person had underwear that covered, that it's an attempt?
Yes, Your Honor. The statute
So what isn't an attempt?
What isn't an attempt is when I think it's important to look at the 5 factors, the 5 elements of the crime, where the photograph or the surveillance has to be willful, and it has to be done with the requisite intent to specifically secretly hide or conduct such activity.
What are the circumstances that you're alleging were here? Is it that the women were seated on the MBTA?
As to the first one, I believe the woman was seated, but specifically in the application for criminal complaint, it states, and this can be found on page 50 of the record appendix, that a witness observed the defendant taking a photograph up a woman's skirt.
But where was the woman?
I believe she was sitting on the train.
So she was sitting on the train?
Yes.
And he wasn't in a position below her?
There's no evidence as to what his position was or the positioning of his phone. I would also point the court towards a record appendix.
But there's that it was at his waist.
In the second allegation, the second charge of attempted, there is evidence that he held the phone at his waist. He was described as being 2 or 3 feet from the woman, and he directed it at an area, I believe it said her crotch, but there was specific, at least an allegation in the application for criminal complaint that it was directed to reveal her crotch area.
Is there any indication that the camera could see things he himself could not see?
I believe so, where it specifically says, at least to the second charge, that it was capturing the area of her crotch.
But his eyes could too.
I don't believe his eyes could. His eyes were not by his waist. There's no allegation.
But you don't know what was, if you're seated directly across from somebody, you can often see quite a lot.
Well, there's no allegation that he was seated.
Uh-huh. So you don't know where he was.
But somebody
No,
might
I believe
have been.
At his waist, he would be perhaps at her head level.
There's in the application for criminal complaint, there's no specific evidence as to their heights. I believe it says that the defendant was standing, that he did have a cell phone by his waist, that he was standing 2 or 3 feet away from her, that he put his phone in a position to direct it to the crotch area underneath, this was a female officer, her skirt. So I do believe that from that is a reasonable inference that it was capturing an area that someone standing eye level wouldn't be able to see.
But somebody
Somebody
sitting would.
seated could.
Your Honor, I don't believe that that's true.
Doesn't it all go to, sort of the expectation of privacy if you are putting yourself in a position where, things can be seen?
Yes, Your Honor, and I think that's important. I think it's critical to the analysis here, and I think the expectation of privacy, I disagree with my sister that the expectation is just in a place or circumstance. Giving every word in that element meaning, it's a place and circumstance where an individual would have an expectation of privacy not to be so photographed, videotaped, or surveyed.
But who was nude or partially nude, that's also part of it.
That is, Your Honor, but
I don't think people consider themselves partially nude who are wearing underwear, frankly.
Your Honor, I believe that you would consider that area, if someone causes the exposure of that area, to be partially nude, and I would specifically turn you towards the definitions as supplied in 105 Section A, in which it defines, the legislature has defined partially nudity as the exposure of human genitals, buttocks, pubic area, or female breast below the point immediately above the areola. Now, importantly, it doesn't...
By the person.
No, it doesn't say who has to cause the exposure. It just says exposure. And if you look at the common definition of exposure, it means, and I turn to Webster since this is a source that was readily available to the legislature when they wrote this, exposure is defined as the fact or condition of being exposed or the manner of being exposed. Exposed is defined as to cause to be visible or open to view. Now, there's no, in that definition, there's nothing to say that it's the victim herself who has to cause the exposure. But not only that, I would point the court towards its case law concerning strip searches, specifically Commonwealth v. Morales, 462 Mass at page 341.
That's where somebody pulled down the pants of the defendant.
And he lifted the waistband so the defendant's buttocks became visible.
To others than the officer who was looking at him.
But specifically, this court says that that officer caused the exposure of that area.
Right. If you pull the waistband down so that everybody who's standing there can see, it seems to me that's.
It seems to me you're torturing the word exposure to try to fit it, because you're going to have trouble convincing us that this works the way you want it to work. It's hard to imagine, even if you're correct about part of it, that that someone photographing up a skirt the person doesn't have an expectation of privacy. I get that part of the argument. I certainly would have an expectation of privacy and not expect someone to take a selfie. But the part about exposure, I think, is problematic for you.
Your Honor, I disagree with that because, and I would point the court again to 105A, which specifically contemplates, when it's talking about surveillance, the ability of an individual to use certain devices, such as a cell phone, to aid in viewing areas. And I think when you think of a cell phone, it definitely is the type of device that could be used, put at a certain angle to cause the exposure.
That's right, such as in what I think this probably contemplated at the time, putting it in attics and being available, even if you yourself aren't in the attic, watching someone in the bathroom, something like that.
I still don't get it. I mean, you've done a nice job of trying to sort of fit Webster's dictionary in here and twist the words around to make them marginally applicable. But no common sense reading of this statute would include the conduct you're talking about, would it?
I disagree with that, Your Honor. Where there is nothing in the statute that explicitly says who has to cause the exposure.
Whoever willfully photographs another person who is partially nude.
Yes.
Is that clear?
Yes.
And you sitting on a train are partially nude?
Yes. If you
fully dressed?
Yes, if you read it in conjunction with 105 Section A.
So everybody in this courtroom is partially nude?
Could be partially nude, yes.
Not could be, is.
Is.
Well, not...
I guess
According
we are.
to your definition, depending on where the camera may be.
Well, it is that the person with the camera can use the camera as an aid to expose your partial nudity, yes.
Make someone partially nude.
Yes.
You're not partially nude now, but if I take a photo of you, maybe you are.
No, I disagree with that. I'd say areas under my skirt, which I've taken the proper precautions to maintain my privacy, yes, they contain partial nudity because they contain the parts of my body enumerated by the statute.
Even though you have clothes over them?
Yes, because I've taken the necessary precautions to exhibit a subjective expectation of privacy. Now, it could be that a person uses a device to expose this partial nudity because they could use a device to expose these areas of my body.
The legislative history here,
yes.
Is it what your sister says, that it really was, at the time it was passed, the goal was peeping Toms and putting cameras and
locker rooms and places like that?
It may be, quite honestly, I wasn't able to find anything that was as explicit as that. I can tell you about the proposed legislation currently, specifically as to Representative John Skyback. He specifically has moved to amend it to include these intimate areas based on an incident in East Hampton, including a individual who was a volunteer with a video camera. He would tape things such as public event meetings, and when he was taping this, individuals noticed that he was using the camera to zoom in on certain parts of women's bodies, specifically their cleavage, and he was using it to try to upskirt these individuals. So
Down blousing now, we have
down
upskirting
blousing
and down
and
blousing.
upskirting. So this individual was doing that. I'd say that defeats my sister's argument that this only would apply to a private place as specific.
But that's a piece of pending legislation that's not before us. Lots of states have, as a result of incidents like you have just described, passed very specific, explicit laws at this very subject. We could certainly do that too, couldn't we?
You could do that, Your Honor. I'm saying it's not necessary to do that here. I would also say that unlike those statutes, this statute is different in that it contains different elements, specifically the fourth element that ties the reasonable expectation of privacy to both the place, the circumstance, and the manner in which the person is surveyed. And I think that's key here.
May I ask, in your opinion, is there a difference between the expectation of privacy for one who observes using their eyes as opposed to the expectation of privacy with a camera? Is it all the same?
I would say, as to this, so when you talk about expectation of privacy, I think that it's appropriate to use the traditional analysis and ask subjective and objective. I think as to eyes, it necessarily, yes, I think it's different because I think that the technology can be used to cause a further invasion that an individual.
But it's got to, I mean, you got to, I mean, I take it in this case, as you said, he's at least 3 feet away. It's not as though he has put the camera up the skirt physically.
And I don't think that's necessary.
But it means somebody could see just what the camera is seeing.
I disagree with that because of the angle he was holding the phone and because of the capability that cameras, such as cameras on cell phones, have, the ability to zoom into an area to see it in more detail than you necessarily would be able to see with your own eyes.
But you don't even know if he was standing or sitting. And if he was standing, you don't know anything about the angle of the camera.
I disagree with that, Your Honor. I would again point you towards the application for a criminal complaint in which it says specifically to the second incident that he was standing, that the camera was at waist level, and that it was directed in such a manner. However, these are all things, this is all evidence that the Commonwealth would elicit at trial to show beyond a reasonable doubt that the defendant is guilty of committing this crime beyond a reasonable doubt. The problem with here is that we haven't gotten to that stage yet, so it's impossible to answer your questions because the Commonwealth has not been put to that burden of proof.
Now, going back to legislative history, what meaning do you give to subsection D, which expressly says this does not affect changing rooms where they maintain some security, meaning security cameras in order to protect against theft? I mean, does that not suggest that we're talking here about locker rooms, changing rooms, that kind of bathrooms, that kind of context?
Yes, Your Honor. It does suggest that that is one of the places and circumstances that the legislator contemplated. I don't think that necessarily means that they weren't contemplating that it could be applicable in other places and circumstances.
And would they use the terms nude or partially nude to mean what you say it means if that's what they intended?
Your Honor, admittedly, this language is not the best language. I would agree with that.
Well, maybe, I mean, arguably, one could say it's the best language if the focus of the legislature was to guard against secret cameras in locker rooms, changing rooms, bathrooms. It's perfectly good language for that.
While it could be yes, that's true. I don't think that you can read that to exclude other places and circumstances that it could apply to, especially where the type of surveillance, the photographing, the videotaping is directed at the parts of the body that do contain the enumerated body parts that are spoken of when they speak of partial nudity.
All right, let's assume you're right, okay? And let's assume that somebody is doing a piece on people in subways.
Sure.
What can they photograph and what can they not photograph to be in compliance with the law?
Importantly, I think that they could, again, I would point the court towards the elements of this crime, specifically the third element, which requires that the person taking the photograph has to have the intent to secretly hide or conduct such activity. I don't know in your hypothetical whether that necessarily would be the case where they are taking a picture.
Well, I assume they're trying to get candid shots, so the nature of a candid shot is probably not to say smile for the camera.
Sure. Sure, and in that instance, I believe it would be a jury question in which they would ask at that area whether the individual who is sitting there had a subjective or objective expectation of privacy that they would not be surveyed in such a manner.
But doesn't that make it a bit difficult to do these kinds of photos if you're at risk, depending on what you may photograph, that you're going to find yourself in court?
Well, Your Honor, while that may be true, just because an individual wants to take such a photograph doesn't mean that the state doesn't have the ability to reasonably legislate that type of behavior. I would point the court towards such street artists such as Shepard Fairey. Just because they wish to spray paint on buildings and that has artistic merit doesn't mean that they have the ability to do so and
Are
not
you
be prosecuted
suggesting
by
that
the law.
even if there were a statute like other states that have statutes that more explicitly define upskirting as a crime, you'd have the same issue about the candid camera photographer journalist?
You may, but so long as the statute is not at the content of the photograph, I believe that it would pass constitutional muster.
Can I just ask you one question?
Sure.
If I understand correctly, the attempt here, the reason it's an attempt is because nothing that fits within the definition of partially nude was shown in the photograph. Is that right?
Yes, Your Honor.
So is there any limit to attempt?
Well, Your Honor, yes, there is. There has to be an overt act to commit the substantive offense. And here, where he did aim his camera specifically at areas...
So it becomes a statute about aiming your camera, basically.
Well, Your Honor, that's specifically contemplated by the language of this statute, where it says that electronic surveillance is defined to view, obtain by use or aid of a camera. He used the camera to obtain this person's visual image. Specifically, he was trying to obtain the visual image under a skirt, which contains the enumerated places, the enumerated body parts.
Counsel, we're going to have to leave it there. Thank you very much.
Thank you.
SJC-11389, Jason McDonald versus Kevin James Caruso.
Good morning, Counsel.
Mr. Chief Justice, good morning. And if it please the court, I have attempted in putting together this appeal to simplify as much as I could what the issues are. Unfortunately, we're dealing with something that is very complicated. Domestic violence, as the amici point out time and again, is an affliction on society that needs to be addressed, and the legislature has done so by the mechanism of Chapter 209A. In this case, at the very beginning, I'd like to correct an inaccurate factual statement in my brief, and that is that there was never any prior issue between Ms. McDonald and Mr. Caruso. I overlooked the fact that in 1994, there was at least briefly an abuse prevention order issued in Poughkeepsie, New York, and the fact that was in March, I believe, of 1994. The parties stayed together until June of 1995 when Ms. McDonald fled. I apologize to the court for having overlooked that before.
So what that leaves us with is the report that he threatened to kill her, and he possessed 7 guns.
Yes.
And this abuse order that was issued in Poughkeepsie in 1994.
Yes.
That's it.
About which we know nothing, except that the parties reconciled, obviously, if they stayed together until 1995. Now, there are, as I have...
What was the year that he sought to end this? In other words, the order happened, and then it was made permanent by Judge Sebadis.
2011.
Okay, so that was...
That was 10 years after it was made permanent in 2001. The initial issue, obviously, is whether the Mitchell standard, when applied to this case, would lead us to believe that the order should have been vacated in
Well, the
2011.
ultimate question is the safety of the victim, isn't it?
That's the primary ultimate question, yes.
Okay.
There's a secondary question, and that has to do with the rights of a defendant in a case like this.
Well, I
to be
know
absolved.
you have reported that he's been inconvenienced in a number of ways.
He has.
Is that what we ought to be looking at?
I think that that's a secondary thing to observe. Absolutely, it's secondary. But it still is a matter of some importance because his reputation is now smeared by the existence of this if his criminal record is checked. And let's keep in mind, this statute describes this as civil, but its results go on the criminal record of the defendant.
Did he ever appeal
He did not.
any of these? No.
No, he did not.
So he
Not
really, in other words, never really contested.
Not in 1999, not in 2000, not in 2001. He did not appeal. And it's, I suppose, inviting to say, well, he should have appealed. And if he had known me, he might have.
But your argument's a little different now, though, right? I mean,
Yes, it
I mean,
is.
I take it, what might have been the case in 1999, 2000, or 2001, you're saying the circumstances are so fundamentally different now that it is not proper to
Correct.
leave it in place.
Correct. And if we apply the standards set forth, it's not standard, but the language of Smith versus Jones, that case pointedly discusses the effects of time and distance on the need for an order going forward. And one can assume that each of us knows from our own personal experience that there are things that we did now, 16 years ago, that we would never do now. We grow away from old ideas to new ones. We mature. We develop different perspectives on life. And if it happened that in 1994 or 1995, which are the critical years here, Mr. Caruso may have been perhaps a little too testosterone charged or maybe a little too angry in general. It is likely that he will have matured out of that. Most people do.
But is your problem here with the standard of clear and convincing evidence or with its application in this case, or both?
Both. It's both, Your Honor. I have, as I stated in my brief, the only thing that Mr. Caruso could have done to make it more obvious that he no longer represented a threat was to have died. He separated himself intentionally or not. This was probably had nothing to do with his move from upstate New York to Park City, Utah, but he's 2,100 miles away. Now, we know that if Miss McDonald were living in Uganda, he could get there. It would be possible, but is it likely? And where there has been nothing since 1995 involving contact between the parties, and only a question whether in 1999 Ms. McDonald may have seen him at the boat ramp in Plymouth.
Well, didn't she report that she had received a number of unsolicited contacts from different mailings, advertisers, unsolicited things?
She reported that, yes.
Yes. They
So-
came from somewhere, and
They came
and
from
she,
somewhere.
and she said the handwriting resembled his handwriting?
She said that. And she said it came from the right area code or zip code, whichever, from the upstate New York area. So the question is, in the absence of an existing order, had he sent her flowers, would that have been threatening, as it was in the case of the husband who sent flowers to the wife when there was a live order? There was no such order here. The fact that he may have sent if he did something by mail, or if he had given her name to her phone number to a telemarketer, does that objectively create a realistic fear of imminent physical harm?
Well, it certainly says, remember me.
It says, remember me,
Yes.
When was that in relation to 2011?
1999.
I take it it's fairly significant to your argument here that Ms. McDonald did not contest
Correct.
Mr.
There was
Caruso's
no
motion.
opposition. Now, the case law says, and the appeals court pointed it out, that there doesn't have to be a live opposition.
I understand that, but I take it it's not you would say it's not irrelevant.
I would say that it is very relevant.
That's what I'm saying.
That there was no opposition. And in this case, we're outside the record a little bit here, but I talked to her personally, and the assistant register in the probate courtroom on the day I argued the motion called her to ask if she was coming to oppose, and she said no. The lack of opposition, I think, is more important in this case than it would be in a case in which the defendant was beaten up five days ago, or rather the plaintiff was assaulted by the defendant 5 days before. In this case, we're talking about 3.5 years from the time the parties separated. And if there was contact, if it is credible that Mr. Caruso sent those letters, that was 14 years ago. It was 12 years before he filed the motion to vacate. Now,
can I just explore a little bit? I mean, the judge wasn't required to enter a permanent order in 2001, I take it, right? So I'm trying to understand what it is that people ought to be thinking about when a judge is talking about entering a permanent order. Permanent, underscoring the word permanent, so that it's not a secret to anybody who's involved that this is going to be something we don't have to come in every year and report on any recent activities or anything else. This is it. This is permanent.
Yeah.
Barring something exceptional, this remains in place.
correct.
What's wrong with that?
That standard is, rather, that proposition is fine, as long as we have a means to review it as time passes.
Well, there is a means to review it, and the judge said this was not really within the ambit of the exceptional, extraordinary.
I understand that, Your Honor, but the judge, I would respectfully add that the judge incorrectly found that this did not constitute clear and convincing evidence, as established in the Mitchell opinion, with my apologies to Justice Duffley, who authored it.
And is that because it's an abuse of discretion, or is that because he was clearly erroneous?
She was plainly wrong, Your Honor.
So you say the standard with regard to clear and convincing should be a clearly erroneous standard?
I think that that might help, but that's not what I would advocate. What I advocate is a set of written standards that perhaps the legislature should address, but by the same token, this court can also establish a system of review. And it's the Carfagna case from New Jersey that's cited in my brief, Carfagno actually, that's cited in my brief that sets out an 11-point system of examining these questions, beginning with whether there's opposition or whether the plaintiff wishes to continue the order.
I take it that the only thing the judge had before her was a verified complaint.
Correct.
So there was no other affidavits confirming the allegations in the verified complaint.
And I would simply say, Your Honor, that a verified complaint is as sacrosanct as is an affidavit or even deposition testimony.
I mean, other affidavits, perhaps, about his life in Utah and that he is in fact married. And I mean, I'm just saying this was a very slim record for the judge to consider.
It may be that from at least one mind, it was inconceivable that the passage of 11 and a half years with no contact whatsoever would not constitute clear and convincing evidence. Now, if there is a lapse there, as I stand here, I could conceive of sending in more affidavits, but the case law, Commissioner of Probation versus Adams, I believe it is, indicates that this is permanent. The existence of this on the criminal record is permanent, and it cannot be expunged. So it was our position, mine and Mr. Caruso, that so much time had passed, there was so much distance, there was a total absence of violations of the orders, and there was a lack of opposition, was enough to carry the day for us. And with respect to the judge's decision to deny it, all that was done was to quote from the Mitchell opinion language about changed circumstances and the absence of a proof of the non-existence of a need for the order. Now that is very difficult to do because we're predicting the future. We have something like clear and convincing evidence that there's no longer a need for the order is no more simple than E equals MC squared. Doesn't look hard, but try to explain it. And that's the same thing here. My suggestion is that what we need is a set of specific standards to apply. This will take the Kentucky windage out of the process. It will allow district and probate court judges and any other judge who hears one of these to make a studied examination, to make a take a controlled look at the process. My suggestion with 5 seconds left is that in this case, clearly there's grounds to vacate the order, and second, that we need a standard going forward.
Thank
Thank
you.
you, counsel.
Thank you, Your Honor, Mr. Chief Justice.
SJC-11357, estate of Stephanie Moulton versus Nicholas Popolo.
Let's proceed.
May it please the court, good morning. I'm John Frumer on behalf of the 18 current and former members of the Board of Directors of North Suffolk Mental Health Association, a not-for-profit provider of mental health services. The director defendants are the appellants. No one is here today to debate the tragedy which took place on January 20th, 2011. What we are here today to determine is whether or not the definition of employer in the Workers' Compensation Act is to be read to include directors of a not-for-profit board for purposes of application of the immunity provisions of the exclusive remedy of the Workers' Compensation Act. What I would like to direct your Honor's attention to start with, I believe, is the definition of employers itself within the statute. It says in the first line that employer contains individuals or corporations. It also says that any one or more of these, if they're in a joint enterprise, can be considered to be the employer. We know that the legislature, when they drafted this, certainly had in mind not-for-profit organizations, and by looking at the last line, where they specifically said, the word employer shall not include nonprofit entities as defined by the Internal Revenue Code that are exclusively staffed by volunteers. There are no volunteers, that's not an issue specifically here, but the point is the legislature bore in mind not-for-profits when they drafted this definition. Had they wanted to exclude boards of directors, either as a board or individual members, they had the power and the knowledge at the time to exclude it in that definition. They did not do so.
But your argument is not limited to nonprofits with regard to directors. I assume the same argument would apply for a profit corporation.
Right.
It may well, Your Honor, but quite frankly, we're here today on behalf of the members of a board of a not-for-profit. People who are volunteering.
But in theory, it is the same, isn't it, what Justice Gant says?
I believe it would be, Your Honor, yes. What we can glean also from review of that definition, in addition to the fact that it does not exclude the directors, is the general intent, the notion of what the legislature had in mind when they enacted the Workers' Compensation Act. What they were attempting to do was do away with piecemeal tort litigation, which was arising from injuries to employees in the workplace. And what they did was they balanced all of the interests of the various people in society and in the workplace, and they came up with a Workers' Compensation Act, which, as a quid pro quo, makes the job of the employee significantly easier if they are injured or die in the workplace. They don't have to prove causation. They don't have to go through all sorts of proofs that they would in a typical tort action. What the employer gets then is the certainty from a commercial perspective of what it's going to cost for them to run their business. Now, to try to separate the corporate governance body, the board of directors, from the corporation itself is effectively illogical. We know that from Boston Athletic Association that a corporation cannot act absent the guidance and direction of its board. We know that also from that case that if the members of a board act in sufficient numbers, it becomes an act of the corporation. We also know from that case that that no individual director is capable of doing something that is an action for the corporation itself.
So are you saying, I'm trying to get to where the plaintiffs are and where the judge is as well. This concept of the directors are the employer, I mean, they're one and the same. So you would say that's as a matter of definition, so you don't have to show waiver? I'm just not clear what you do about this affirmative defense piece of this.
The waiver that plaintiffs brought up, we believe, is actually almost a non sequitur. The waiver comes up in a provision of the Workers' Compensation Act which permits an employee to waive out of application of the Workers' Compensation Act scheme and instead to reserve for themselves the right to resort to tort litigation in the instance where there's injury or death in the workplace. Factually, that couldn't have been pled here by the plaintiff because this employee did not waive out of application, and legally, as a practical matter, they didn't even plead it. So it's not our burden, it's not defendant's burden to raise that at some time in pleading, such as in answers in an affirmative defense. Instead, it simply is missing a standard of pleading, which is the plaintiff's burden in the complaint itself.
Judge Wilkins' decision seems to have turned on the idea that it's premature to dismiss the complaint, that this really should go to summary judgment, and we'll take another look at it then. He said that the complaint does not establish with sufficient certainty that the defense of workers' compensation exclusivity will prevail. Tell me why he wasn't right.
Your Honor, we believe he was not right because if you look at the specific allegations within the complaint in light of the standard which this court has set in Iannacino, we do not believe that there are sufficient heft in the facts as pled, and that the only thing that there is really in the complaint are bare labels and conclusory allegations, which are insufficient to meet the Iannacino standard.
But I take it your position's a little different. I thought you say, as a matter of law, the directors are the employer. So the allegations don't matter in that sense, do they?
We believe that is true, Your Honor, as well. That simply as a matter of law, that the employers, that was the intent of the legislature to contain within the definition of employers boards of directors.
So
but I take it.
Go ahead.
But I take it that a director acting outside of their role as a director or in violation of their fiduciary duties as a director who causes an injury to an employee, isn't that essentially what Judge Wilkins is saying might have occurred here, or at least it's significantly alleged or adequately alleged?
It's insignificant. It is not sufficiently alleged, firstly, Your Honor, in that there is not a circumstance where a director, as a director in casting his or her vote, acted in a manner which breached a duty which a director has that's recognized under law.
So it would have to be something far more than what is alleged here.
That's correct,
An
Your
act
Honor.
far further from the director's sort of corporate conduct.
That's correct, Your Honor. And if that were the case, then, for example, if there in fact were a fiduciary duty between an individual director of the board and this employee, that would have had to have been alleged. It's not alleged. The special relationship necessary to invoke a duty was not alleged here.
But aren't the plaintiffs, and I may be wrong about this, but aren't the plaintiffs saying that, look, there was a conflict of interest here between the vote that the directors took and the work, you know, the business, the purpose of the corporation. And they were acting essentially ultra vires. They were acting outside the authority of the corporation. And it's that relationship, the nature of that particular vote or those votes and that activity that exposes them to individual liability that's not covered by the exclusivity provision.
But that, Your Honor, is not sufficiently pled, firstly, by the Iannacino standard, in that there are insufficient specifics other than the conclusory allegation, as Your Honor just articulated, that there was a conflict of interest. There is no conflict of interest shown in the pleadings.
No, okay, so you're saying that it's not enough to allege that there was a conflict of interest. They really should have spelled out what the nature of the conflict was.
That's what Iannacino says, Your Honor.
Okay.
Yes.
I'm a little bit lost now in view of what you've just said. Let us assume that they put together a complaint which says in extraordinary detail that the directors have their own incentives to get their patients into this facility, and regardless of the danger that they pose, and that they put together a set of rules which would make it easy for them to get their patients into this facility, which serves their interest as doctors, but perhaps not the interest of the employees of this entity. Assume that was done in great detail. Does the case survive?
Under those circumstances, it still wouldn't, Your Honor, we would contend, because there is not a duty recognized in law as between the directors, as individual directors or as members of the board of directors, to the employee. Therefore, if there is no duty recognized, there can be no breach of that duty.
Okay, so you're saying there's no breach of fiduciary duty there, but they've also maintained a negligence claim, and they say that that conduct takes them outside of the protection of the Workers' Comp Act because it's being done for their own benefit, not for the benefit of the corporation.
But, Your Honor, the comprehensive nature of the Workers' Compensation Act doesn't permit a negligence claim, whether it sounds as negligence, gross negligence, even willful conduct. It is included in the comprehensive nature of the remedies of the Workers' Compensation Act.
Maybe it's the same question Justice Gantz is asking, but I'm confused. If you're theoretically saying the employer, that the directors and the nonprofit corporation, North-South, are one and the same, identical, for purposes of the Workers' Comp Act, right?
Yes.
Well, then, wouldn't it follow that looking at whether an individual director or the director or more had breached their duties doesn't even arise? I'm just, where do you go from looking at the board and the entity as one to looking at the board members individually?
We don't, Your Honor.
No, but you answered Justice Speed and said, well, yes, if the pleading, if the facts were better alleged, maybe there would be a cause of action. So I'm just not clear how that works.
We don't believe that the courts need to get to this level of analysis at all. Things get confused because we're taking such a fundamental premise of the law, which is so clearly part of the intent of the comprehensive legislation embodied in the Workers' Compensation Act, and we're trying to drive a wedge in between two parts of an organization that are so inherently and immutably tied, its board of directors and the corporation itself. And in doing that, having what this complaint does, basically throwing the whole Workers' Compensation Act on its ear, we come up with certain issues which are perplexing, but they need not be perplexing.
But so it would be your position, let's just say, as Justice Gantz was saying, that you really did have a cabal among the directors who created this really reprehensible policy. I'm not saying that's the case, but totally reprehensible policy, no standards whatsoever. We don't care one bit whether our employees are safe or not. In fact, we'd like them not to be safe. And they implement that. There is no cause of action against them?
There were two things, Your Honor. Firstly, the duty of that board is to the corporation. The exclusive right in the Commonwealth to address an alleged breach of a duty of a not-for-profit by the members of the board is in the Attorney General.
So I take it then your position is that it doesn't make any difference what they do so long as they did it while wearing the hat of the corporation. It is the act of the corporation for purposes of civil liability.
Well said, Your Honor.
For at least vis-a-vis an employee. No, I mean, I take it that's not true.
For purposes of
an employee
exclusivity.
because of the Workers' Compensation Act. If there
What does, and I didn't look at it again. What about the Wang case? Does that come into this at all?
I'm not sure.
You know, the person who was employed by Wang, and it was the plaintiff was suing because there had been an interference with contract?
There are a few isolated grounds where this court has said that there is a deviation from the Workers' Compensation Act. I think it's tortious interference with contractual relations, a few other things which are not employment, workplace, tort related. But this, Your Honor, given the tragic nature of what happened here, this is clearly a tort in the workplace contemplated for coverage by the Workers' Compensation Act.
Your time is up.
Thank you, Your Honor.
Good morning. Sean Regan representing the plaintiff, the estate of Stephanie Moulton. Your Honor's in the courtroom with us today are Stephanie's parents, Kim Flynn and Robert Moulton. I also would like to begin by saying, may it please the court, but there's nothing about this case that should please the court. This is not a tragedy. It's a bloody murder. 7 days ago, Mr. Chappelle was convicted of that murder. The essence of the allegations that we're making in this case is he did not act entirely alone, that others, in this case the directors of the corporation, are complicit. They are complicit because they knowingly have taken many criminally dangerous persons, put them on the street, and put them in situations where those around them have no idea of the threat posed. They work through a labyrinth of corporations. Publicly available information would reflect that there are more than 10 corporations associated with North Suffolk located at the same address in Chelsea. They operate more than 20 pieces of residential real estate. There are at least 25 corporations associated with North Suffolk. And just last year, they pulled in more than $43 million in various state.
Are you suggesting that the directors are making a huge profit here, Mr. Regan?
I am suggesting this is very big business, and it offers a great opportunity for self-dealing on the part of the directors.
And that's what you're accusing them of?
We are indeed.
Okay.
We are alleging specific, intentional acts in conflict with their duties as directors.
So would you say that any organization, nonprofit organization that serves this population of patient, insofar as dangers lurk, those directors would be equally liable?
Insofar as they may be trading on that position to take advantage of what amounts to a captive clientele for their personal practices, their personal businesses, and enterprises in the community, I would say yes, that is the case.
Now let's assume that everything you say is right. I'm not saying it is, but we'll grant you that assumption for now. And all of the conduct was committed by an officer as opposed to a director. Do you have a claim?
My understanding would be no.
And then if there's no claim, if it's done by an officer, why would or should there be a claim if it's done by a director in terms of the purposes of the workers' comp?
There's a well-established co-employee rule under workers' comp cases. Presumably an officer is an employee of the corporation, just as Stephanie Moulton was. There is a distinction which you were developing with my brother between the corporation itself and the directors. Directors are subject to suit by the corporation for breaches of their various duties. That clearly establishes them as two separate persons or groups of persons.
Well,
rightly or wrongly, the co-employee rule may...
But officers are
subject to suit for breach of their duties.
In that case, it may be that the co-employee rule will not apply. I'm just thinking categorically that we are not dealing with employees, in any sense employees of the corporation, when we're talking about the directors. And that is a clear distinction. And they are not in any common sense use of the word, the employer. They didn't pay Stephanie a check. They didn't direct her work.
Well,
they set up the game. I'm sorry, Your Honor.
No, you go ahead. I interrupted you.
If the directors had even allowed, much less required, that a proper examination be done of prospective clients, none of us would be here.
If there were no conflict of interest,
yes,
but the vote of the directors was total incompetency, was based on total incompetency and in ignorance of standards, would you have a claim?
My claim would be much weaker. Whether it would survive or not, I don't know. But the knowing conflict is the essence of our allegation, Your Honor.
But it's the action of the corporation as the employer.
But it's the manipulation of the corporation by the directors which is what this claim is about.
But the employer was the corporation.
Agreed.
And why aren't you bound by that fact, that the employer was the corporation and your exclusive remedy is Chapter 152?
Because I'm not suing the employer. I'm not suing North Suffolk Mental Health Associates. And we're down now to the question of whether we can equate an individual director acting in his own interest with that corporation. And it's obviously our position that you cannot. They are distinct from each other.
So is the director part of the employer as long as the director is acting within a certain range of acceptable conduct, but then not the employer if they're acting outside?
I don't think an individual director is ever cognizable as the employer. The board, acting as a board, as the highest management body of the corporation, may be identified with the corporation.
So you would turn, if I understand the argument then, if no individual director is the board, for purposes of workers' comp, there's absolutely no protection for the directors, unlike anybody else.
I would say that's correct, Your Honor.
You would say or would not?
I would say that that is correct.
So for purposes of workers' comp, just let me finish, it would be just the same as if, it is the case that if an officer or a director participates in a decision that causes injury to somebody who's not employed, there may be a personal cause of action. You would say it's exactly the same even though the person is employed by the organization.
Yes, with respect to the individual director acting in his individual capacity, yes.
So who in his or her right mind would ever possibly serve as a board member of such a nonprofit?
Anyone who is willing to fulfill their fiduciary obligations and not engage in self-dealing, Your Honor.
Oh, well, that's assuming, you're begging the question, right? You're going to get sued.
It's a question of evidence, Your Honor. The denial of the motion to dismiss has not established our claim. I still have a heavy evidentiary burden, and this is off the record, but we have done some discovery, and it appears to me that many of our allegations have been substantiated, including allegations of conflict of interest.
If a board member votes against the majority, is that board member nevertheless exposed to liability in the circumstances of this case?
I would say not, Your Honor.
And if a board member does not have a conflict of interest, but votes with the majority, is that board member liable?
I'm going to have to go down the list of 18 individuals named here, and for each one of them, it's going to be my burden to discover and to demonstrate the conflict of interest and to discover and demonstrate the manipulation. I believe I found it with several already.
But you've named every single one of the 18 as defendants, have you not?
Before discovery began, Your Honor.
And if the cabal of those with a conflict of interest does not in and of itself constitute a majority for purposes of board action, and others voted with the majority who did not have a conflict, is there still liability as to everybody?
That's another difficult factual question, because with respect to those who did act out of a conflict, those that did engage in self-dealing, I suppose it would be a question for the jury to decide to what extent, if any, that was instrumental in the subsequent actions and the subsequent killing. But at this stage of proceedings, Your Honor, the Workers' Compensation Act is not a bar to this action proceeding. I would suggest that the charitable immunity statutes, 231, Section 85K and 85W, provide, it's an analogy. In some sense, the legislature has already addressed what principles would apply. Those statutes grant a limitation of liability for charitable corporations and for their officers and directors. But each of them provides that if you have willful, intentional, bad faith conduct, that shield doesn't apply. even if there was some protection afforded any place under the comp statute to individual directors, policy demands that you not provide a shield for willful, intentional self-dealing, which results in these types of injuries and death. Otherwise, you're granting a license to kill. And that is what happened here.
Now, help me to understand your claim. I understand your claim is that the medium of harm here was the operating policy and the admissions policy, that those policies were such that they permitted this individual to become admitted and resulting in the death of Ms. Moulton. That's a board act, correct?
Yes, Your Honor.
But because it is a board act, is it not an act of a corporation by its very nature, as opposed to an act of an individual director?
The answer is yes, but it is also, we allege, the product of self-serving manipulation by one or more of the directors. It is true that the Board of Directors sets the policy. Board of Directors could delegate to Director 1 the handling of the money. He might write himself a check and leave town. That's still an official action. He was delegated that job and he handled the power that was given to him. He just did it wrongly. The directors are delegated the job of setting policies, and they've done so.
And if they delegate, this goes back to Justice Gantz's first question, they delegate the setting of the development and adoption of both the admission and operations policy to the CEO of the North Suffolk Center, there would be no liability. That's right? Even though that CEO may have conflicts up the yin-yang.
I believe that gets us into another factual question, Your Honor.
But assuming that to be the case, you would say no liability, isn't it?
If we assume that I cannot demonstrate self-serving manipulation led to these policies, I'm out. But I'm out at summary judgment time, or I'm out at trial.
No, I'm just trying to see if, make the point, I think, that I thought you agreed that if this was the president, an employee of the organization, who adopted, was delegated the authority to and did adopt and pushed to the board unsuspectingly a policy that was incredibly unprotective of the employees for his own or her own interests, there would be no liability here in this case because it was the officer who was acting, correct?
If these policies are not the product of the director's conscious, intentional decision, I don't have a claim against them. Your Honor, I think, Your Honors, you've pretty much heard all we have to say. I take it that you have a good grasp of our allegations based on some of your questions, and I just ask your consideration and ask that you deny the appeal. Thank you,
sir.
SJC-11506, Commonwealth versus Robert Wade.
All right, let's proceed. Good morning.
Good morning. May it please the Court. I'm Janet Pumphrey for Robert Wade. Under Section 7 of Chapter 278A, the Court shall allow forensic testing if 6 prongs are met. The Commonwealth concedes 4 of these 6. The evidence exists. The state police have it. There's no claim of obstruction of justice or delay, and the results would be admissible. The Commonwealth disputes factors 3 and 4, that a reasonably effective attorney would have sought testing, and that the DNA testing has the potential to result in evidence material to identity. The Superior Court denied the 278 motion on two grounds. The first denied it on the ground of dismissal without prejudice because of the inadequate affidavit.
Can I just stop you there, Ms.
Sure.
Pumphrey? When Judge Veary did that, do you read, how do you read Section 18 as it applies to that decision of Judge Veary? Is there a 30-day period in which you need to appeal?
No, Your Honor, the statute doesn't say that, and it was denied without prejudice.
Well, I
subject
understand
to,
that,
subject
but
to
it does
refiling.
say, it says...
It does say.
It says it's a final order. I think it says it's a final appealable order, does it not?
It does say, except that this was denied without prejudice.
No,
It
but
could
I
have.
thought that it applied to that as well. I mean, it's just
I would suggest that it does not.
Maybe I'm wrong. I've got to get the statute.
I would suggest that it does not. I don't have it in front of me either, but I would suggest that it does not. That when it's dismissed without prejudice, it's subject to refiling, and the issue was the sufficiency of the affidavit, subject to refiling with an affidavit.
So you refiled.
I refiled.
But then you didn't, you refiled in October, I believe?
I refiled.
And then you didn't supply anything
No, I refiled a bald motion with both within the motion itself and also within my cover letter to the court saying this will be supplemented. Please do not mark it for hearing. Please do not rule on it.
Right, but that was in October, and the judge didn't rule on it till December. What was there? It
didn't. In the meantime, I was filing. I was trying to get myself court appointed because the statute envisions that, and that was denied also. But that was what was holding, from my point of view, that was what was holding it up. So then it was denied. It was denied, finally denied, and I appealed that. And then I moved for reconsideration. And then it was denied again, and I appealed that also. So, but the second prong is, which I think is the most important thing that you have to consider today, is that the Superior Court also found that DNA testing would not appear to have the potential to produce material evidence. The court's findings were erroneous on both of those prongs. As the basis for that erroneous finding, the court made the wholly erroneous subsidiary finding that there were multiple hypotheses supporting guilt in this case, such as penetration by something other than a penis, and that this was an attempted rape and not a completed rape. That erroneous conclusion is completely at odds with the only theory in this case, which was penile penetration into the victim's vagina. And it was completely at odds with the only evidence at all in this case of a rape, which was the semen. There was absolutely no evidence at all of any penetration other than penile, and there was no theory presented of any such other penetration. And also there could have been no such evidence because to prove non-penile rape would have required somebody to testify. In this case, there was no testimony because the victim was deceased, there were no witnesses, and there were no incriminating statements. The court also reasoned that this could have been an attempted rape. But like the multiple hypotheses of guilt concept, the attempted rape, that's completely erroneous because if it were attempted rape, it wouldn't have resulted in semen. And semen was the linchpin of the Commonwealth's case here. I would suggest that this subsection, that the requested analysis has the potential to result in evidence material to identification, would always be the case in a case of rape where the DNA evidence is semen itself. By its very nature, DNA evidence is evidence of identification. And you can think of examples of scientific evidence where this would not apply, and I'll give you two examples. One is forensic chemistry testing in an arson case. That would be Chapter 278A, but that would not necessarily result in identification of the perpetrator. And secondly, in a non-rape case, just a regular murder case, a DNA testing of a saliva on a cigarette butt left at a scene would not necessarily lead to the identity of the perpetrator. But semen absolutely, positively will lead to the identity of the perpetrator.
Let's go back to the facts of the case.
Okay.
What are the facts? Where was he found? Naked in his shack with the victim on the bed, naked?
That's right.
Okay, with a broken hip.
That's right. But I would tell you that 278A expressly says, don't consider the strength of the Commonwealth's evidence. You don't consider a confession. You don't consider a plea.
Well, if the question is ID,
The question's identification.
The dude, right?
Not necessarily so. With the amicus brief that was filed by the Innocence Project basically sets out all the cases in Massachusetts with overwhelming evidence of guilt, where DNA testing proved to be exonerating.
What do you say in both 3 and, well, no, it's in 7. What do you say it wasn't filed for purposes of obstruction or delay means in this context? This is post-conviction.
Well, it really, I think the Commonwealth does concede that it was not filed for purposes of obstruction or delay. And secondly, I've been trying to get this evidence for 10 years. I
understand that,
yeah.
but I mean, I guess my question is, doesn't that language itself suggest something tied with the strength of the case? You don't think so?
I would suggest not. I mean, the entire legislative history of 278A is it's supposed to make it easier for prisoners to get access to evidence. And when you start bringing in the facts of the case, every single one of these cases resulted in a conviction. So every single one of these cases had evidence beyond a reasonable doubt that this person was guilty.
But the defense in this case was not identification.
It wasn't.
And was that defense ineffective under our standards?
I have argued that it was for 2 reasons. One is that he basically argued a consent theory, and he put forward, and the victim did have Alzheimer's. There was not a lot of testimony at all as to her actual competence. She was dressing herself, she was taking care of herself, she was cooking, she was cleaning, she was sewing, she was doing all these things. She had a little bit of memory loss, was the only testimony as to her incompetence. But of course the jury was instructed on lack of competence. But he puts forward, the defense attorney continues to put forward this consent theory, and his theory was, and it comes out in the trial, his theory was that elderly women with Alzheimer's have a hypersexuality. So she came to him for sexual intercourse. If he's putting forward the theory of Alzheimer's, then the jury is going to be instructed on lack of consent, and they were. So he basically proved his client's guilt. But most importantly, you have an affidavit from the appellate prosecutor, basically saying that the defense attorney would not sign an affidavit for her, and he certainly wouldn't sign one for me.
Of course he's not going to sign one for the prosecution.
No, but what he is telling her is that he didn't order he had a reason for not ordering the DNA testing, and that was because he was pursuing this consent theory. Well, the DNA testing was not inconsistent with the consent theory. If he had just ordered it, if it was incriminating, it would have been consistent with the consent theory.
But I gather from Ms. Lee's brief that he did argue Bowden in his closing.
He did, and in my reply brief, I've suggested I did look at every single Bowden case that was ever argued, and it's never, ever, ever successful. I found one success, and I'm sure there probably are others, but in the about 80 cases of Bowden being argued, it's not often successful.
But can we say that counsel was ineffective for not asking for it without knowing whether or not counsel didn't ask for it because he thought that the results would not be helpful to his client and that he would be losing a Bowden argument and eliminating all doubt about the source of the semen?
Well, I would suggest it would really be, just a balancing test. When it could have totally proven innocence, it's a much, much, much better.
But if you apply a strategic, there's a strategic reason, can you get around that?
Well, I think you can get around it because it really is consistent with the consent theory, and the Bowden defense is really not much of a defense. It's at all.
Let's say the defense counsel has a conversation with the defendant. Defendant says, "Yeah, I did it. Of course, I did it." So counsel is now going to request the DNA test to do what?
Well, in this case, the defendant didn't. I wasn't there. This was a long, long time ago. But the defendant has professed his innocence from day one. He was.
Do we know that from his defense counsel?
We don't know that from his defense counsel, but we do know that from his competency evaluation. He basically said that
I was too drunk. I couldn't possibly have
exactly.
had intercourse.
And that's in his affidavit. He was too drunk, and he's told me that, from day one. This didn't happen. And I would suggest that's all the statute says. It says affidavit that states his innocence.
We're trying to figure out whether you've established that counsel was ineffective, which is one of the standards here.
Exactly. And I would suggest that he was ineffective. Because
he lost? Because it didn't work? Because it was a very difficult case?
No, but because he should have asked for it. Because if his client is saying, I'm innocent, he should have asked for it.
When did they know about the other antigen, that there was a third party.
From the beginning. It was testified to.
So the defense counsel knew that there was somebody.
That's right.
And didn't pursue that.
And didn't pursue that. Although that was very strangely argued by the prosecutor, which I've actually got some of that. It was strangely argued by the prosecutor. And I asked, this is in her closing, and I asked the chemist, is that consistent with the defendant being the source of the semen on the vaginal swab? And she explained to you it is. Why is that? Because there are numbers, 1 minus, 1 plus, 1 plus, 2 plus. She told you that that indicates 2 people contributed, but only 1 person whose bodily fluids were in that swab could have contributed to the seminal fluid. That evidence suggests the defendant. Well, that's not what it suggests at all. There were 2 people who contributed to the semen. And that's what the serology says, and that's what the chemist testified to. So it was argued very differently in closing.
With respect to the sort of relationship between Section 3 and Section 7, both of which mention the substantively the ineffective assistance of counsel.
Right, right.
So where is it, in your view, that, if ever, you need to come forward, you, representing the defendant, need to come forward to show that this wasn't ineffective? I mean, that this was ineffective, I apologize. This was ineffective.
It would be here. I mean, it would...
But would it be in the hearing?
Well, I think it would be...
Or would it be in what you need to file with the motion?
Well, certainly Section 3 and Section 7 says both. I mean, it's contained in both, for sure. And I think it has to be in Section 3, and it also has to be in Section 7 as well. And I think...
Enough for Section 3 for you to just say counsel was ineffective for not asking for it, or do you need to do more?
I argued that. And that's actually not the hook that the Superior Court hung its hat on.
I understand that. Yeah. I'm just trying to figure out...
But it is definitely in both, and I think it needs to be argued at the beginning and argued at the end as well.
To put in some information, you can't just assert counsel was ineffective.
And I argued it.
Okay.
I'm trying to figure out how this case relates to the next case we're going to hear. The next case relied not on the ineffective assistance prong, but on the newly developed technology.
Right, newly developed DNA testing.
I think theirs was about the same time as yours,
That's
and I
right.
gather there probably is newly developed DNA.
Absolutely.
But you didn't argue that.
Well, I sort of argued it in my reply brief, if you look there, because, I mean, the serology testing that this semen evidence was subjected to is incredibly rudimentary. I mean, the defendant was one of, hundreds of thousands of people, but could not be excluded. And here it's, with contemporary DNA testing, it absolutely would identify who these 2 people are.
Right, but I guess that's, I mean, I gather there was DNA testing available at that
That's right.
time, but
It was brand new.
According to the next case we're going to hear, there was a whole nother degree of accuracy of the more recent tests that were not available in that.
That's exactly right.
Would that matter here? I mean, it's not argued here, but I wonder whether or not the prong of focusing on effective assistance, if you put aside that prong and say, well, I don't need that prong, I need to focus now on the fact that there's new DNA technology available now, which was not available then, and I'm going to rest on that prong as opposed to whether that changes the equation here.
I don't think it really changes the equation because there's never been DNA testing here, and there should have been. I mean, I think when 278A was passed, I mean, the fear was that there was going to be this just, floodgates of cases, but there haven't been and there won't be because every case now gets DNA testing, no matter what, and so you're only going to have this little window of cases like Mr. Wade, who didn't have DNA testing then and wants to have it now.
Do you think you had any obligation to identify more than just saying DNA testing? I mean, did you need to specify what one you were looking for?
I don't think so. It would be, obviously the most contemporary one and the most discriminating one. So my time is up, but as I said, I've been trying to obtain DNA testing from Mr. Wade for 10 years. I testified at the Joint Committee before the legislature, urging enactment of 278A. And I mean, the question I would like to leave you with is, why won't they let Mr. Wade have access to potentially exonerating evidence? Thank you.
Thank you.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. And it's my understanding that today is the first time this court has interpreted the new statute, Chapter 278A, which came into effect in 2012. And so I might as well start with the policy question that counsel left off with. Why don't you just give it to him, which is the theme of the reply brief and also the theme of the amicus. And I would suggest that that question isn't the right question. That is a question that equates the mandatory pretrial discovery procedures with post-conviction and post-appeal processes. And so we should look at when are we required and when should we give out this type of material for further DNA testing. And the legislature has told us when. I mean, prior to this, we had Rule 30, which told us when, and that was after a prima facie showing, which, of course, the defendant attempted and lost. His attorney was found to be not ineffective for failing to get DNA testing, and that was done by Judge Walker in 2003, and then the single justice of this court denied the defendant's petition under Chapter 278, Section 33E. So we already have a determination that in this case, that
yes,
the trial...
But that's taking into account something that this new statute says you don't take into account.
Well, I would suggest, I understand your question, that is, does 278A change the analysis of
Well, to
Rule
the extent
30,
that you can't take into account the weight of the evidence.
and admissions. 278A says the defendant still has to show that it would be potentially exculpatory, which necessarily looks at the facts of the case.
Well, it has to show that it would go to the identity of the perpetrator,
Yes.
right?
So you would necessarily look at the other evidence in the case. But in addition to that, 278A says the defendant has to make a showing that his attorney was ineffective. If this DNA testing was available, it was. If this evidence was available, it was. If the defendant knew about this evidence, he did. And there was a question earlier by Justice Lank regarding when this antigen was known. And that, my recollection is, that was in March of the year that the trial occurred. So it's 6 months before trial. So the trial occurred in September. In March was when that report came back. And you'll find the report in the defendant's record appendix that explains where the H and A antigens are. Sorry. And that's at defendant's record appendix, page 124, and you see the date of that is March 13th, 1997, so the trial.
But if you know that, doesn't it become relevant then what Justice Gantz was asking? I mean, what's the difference between the technology then and now? And, you know, you could make a different calculus if you think DNA testing is not going to tell you very much or not be particularly accurate or definitive than you would looking, you know, with the benefit of hindsight and, you know, more contemporary technologies that have, in many other instances, shown to be exonerating.
And my understanding is that's the issue in the next case, and the question is that relevant here? Justice Gantz asked earlier. And I would suggest, no, it's not, because there was, at the time of trial, there was a more specific test that was available to counsel. It was admissible. It was admissible 6 years prior to the trial under Kernan, and then Lanigan was 1994, for the purposes of excluding defendants. So if trial counsel wanted a more specific test, he could have gone and got it, but he didn't. So just because there's an even more specific test now doesn't mean that that changes the analysis. He had a more specific test available, and he didn't want it, and there's a good reason why he didn't want it.
What do you think the language in 3 and 7 about for the purpose of obstruction or delay means?
Obviously, because this is the first time you're reviewing the statute, we don't have any case law, which is always my backstop.
I'm looking
what
for
does the judge think about it? And it's not really something that we have been fighting about in the Superior Court. I would think that the obstruction of justice would be some kind of idea that the defendant is trying to pull a fast one on the Commonwealth. For example, use like a bad expert or something, you know, like a charlatan. I would think it would be something like that. I mean, obstruction of justice is pretty strong language, so.
But what's, to what end? He's already been convicted.
Yeah.
I don't understand
Is this
the
a
delay.
template? Does it come from other jurisdictions, the language where, death
I
penalty?
I don't know. I haven't looked at the statutes in other
Wondered if it
jurisdictions.
has a death
sorry.
penalty component to it.
It just, I'm not contending that the defendant is trying to cause any delay here, and I'm not contending.
And you don't read that as some reference to the strength of the other evidence. That's out of the picture as far as you are concerned.
I haven't looked at it that way because, and of course, this court could interpret it that way, but that goes to the potentially exculpatory nature, which is part of it anyway. So I wouldn't necessarily interpret it as being something that's redundant with the statute. But while we're talking about the statutory construction, I think it's important to note the difference between Section 3 and Section 7. My sister is asking this court to order the testing in this case, and it is the Commonwealth's contention that that remedy is not available because there has never been an evidentiary hearing.
And do you think Section 7 has to be an evidentiary hearing?
I think it does.
Because it doesn't say that. It just says a hearing, and I just didn't,
I believe in Section 6A, it talks about an evidentiary hearing. So the court shall order a hearing on the motion if the motion meets the requirements of Section 3. The moving party shall be present for the hearing unless the moving party waives the party's presence at the hearing.
I just didn't see any.
It doesn't say evidentiary, but I would suggest that the defendant has the burden of proof by the preponderance of the evidence, and I would suggest if the determination is that trial counsel is effective or ineffective, then we would look to Commonwealth versus Zinsser, which kind of brings me back, and that would require an evidentiary hearing. I think you'd need to know what counsel knew when he made those statements. What did the defendant say to him? Is the defendant saying...
That would be a Section 7 hearing. In other words, it wouldn't be appropriate to, if the ground is, it was ineffective of counsel not to ask for this, and there's allegations and some articulation of why in the motion, the Section 3 motion, then we go, then there would have to be a hearing, which there wasn't in this case, correct?
Right. And there wasn't because the Superior Court judge and the Commonwealth maintains correctly found that the defendant did not meet his burden in two ways. The Commonwealth maintains that it's in two ways. One, he did not show that his attorney was ineffective. We presented an affidavit. It's my affidavit. I asked counsel. He's a practicing federal prosecutor right now, but I asked him if he would supply the affidavit, and as I noted in my affidavit, he would not do so because of his concerns over his attorney-client privilege with confidentiality of communications. But if you look at what he knew prior to trial, they waited for this evidence to come back. March, it comes back. You'll see in the docket, discovery is then complete, and it gets set for trial assignment. I mean, it's like a day. So that's what they're waiting for. 6 months later, they have trial. So he knows about the A antigen, and he knows about the H antigen. And he doesn't get further delay. He doesn't ask for further testing. And why? Well, the defendant's standing there naked in a room with the naked victim whose hip is broken and her back has injuries consistent with being dragged there. And to this day, we have no idea what the defendant's exculpatory story of that is. Well,
let me ask you, all right, so that's number one. Number
so
two
that's
is
his first problem.
Number two, and you go at length about how the defendant hasn't put in enough of factual innocence.
Right.
Okay. Section 2 says there needs to be an affidavit about that, asserts factual innocence of the crime for which the person has been convicted. And Section 3D says the same thing. I just don't see in the statutory scheme where it is that the defendant has to explain away everything that happened in this case, as opposed to saying, I didn't do this.
Well, I think you see the difference between the words. You have to determine what factual innocence means and what it doesn't mean. Is factual innocence a mere not guilty plea? Is factual innocence, merely wasn't me? Or does factual innocence, does that word mean something more? And I would suggest if he's a plea of not guilty or a mere denial would be an appropriate term for the legislature to have used when they were, if all they wanted him to say was wasn't me. But in this case, we have the defendant saying, I didn't rape her and I didn't murder her because I was so drunk. And his language said, he uses colloquial terms for he couldn't have an erection. Well, that does not say that he wasn't involved in an attempt. It doesn't say he wasn't the person in the room. It doesn't say any of those things.
But felony murder is proved by rape.
By attempted or completed aggravated rape.
But there was a separate indictment for rape,
and he was convicted of aggravated rape.
Right, he wasn't found attempted rape.
But that necessarily would include a finding of an attempt there, necessarily. And the jury were instructed on attempted aggravated rape.
No, but they found him guilty of aggravated rape.
Yes.
So it seems to me that the attempt is kind of out of this.
I would suggest to you it's not. In every crime that you complete, you've started with your attempt. That the jury found more than an attempt does not mean that the attempt wasn't there.
I would suggest that it may make the identity of the perpetrator a live issue, given the fact that you have the two different contributors to the semen.
I would suggest that the term factually innocent requires a defendant to say, I am not guilty under any possible theory.
Which means that this person could not do that because he did not remember what occurred.
Right, and that backflips us.
All people too drunk or too stoned to remember cannot make a claim of factual innocence?
Well, that backflips us to, is counsel reasonable when he's making this choice? Because he's got a guy who, in all likelihood, is saying, I was so drunk, I don't know, because that's what he told the doctor when he was having his evaluation prior to trial. So, I mean, at best, he told his attorney, I don't know, and the attorney stuck with this very inculpatory evidence and a choice, and he makes the choice. And then he proceeds on his closing argument. He has the consent defense. He has the causation defense, the broken hip causing pneumonia, and he has his Bowden defense.
How did the consent defense come in?
They brought in descriptions of, I believe through the Commonwealth's experts, descriptions of Alzheimer's, patients with Alzheimer's. I would suggest in those circumstances he made a good choice, and you can. I detailed his closing argument to some extent in my brief, so that you can see that he used this Bowden defense. I don't think it's appropriate to say I've read all the appellate cases on Bowden, and it's never a success. Bowden's successful at the not guilty stage, so they don't get to the appellate cases. So you don't know how many times Bowden's used. It's used on a daily basis across the Commonwealth, and it's successful in that people get not guilties on it. And here, counsel used that. You don't have that evidence because they don't want you to have that evidence. It's their burden, and they didn't tell you, so you don't know whose stuff is what. And I would suggest to you, just because it's not successful doesn't mean that it's not a valid defense, particularly when the defendant's statements at the scene are, she came to me. And the only other thing he said when found by the victim's son is, I'll leave tomorrow if you want. So I would suggest that we should not ignore the legislative prerequisites.
One thing sticks in my craw, frankly, I guess. You're saying maybe it was attempted rape, even though there was semen found. There was somebody else's something found on her crotch.
Pants. On the pants.
On the crotch of the pants. Not the crotch of the pants, I gather.
Yes.
Isn't this the kind of case where, I mean, doesn't the Commonwealth want to know who that other person was? Especially when it's saying maybe it was an attempted rape and there's somebody else's semen that was there?
I would suggest that the evidence on the pants, the defendant could not be excluded from the vaginal sample or the materials on the clothing. But the crotch of the pants, there's this sample that he can be one of the contributors and not the other. And I would suggest, as we all know, I mean, the reason they want to test this evidence now is that that kind of evidence can stay on clothes for a long period of time when it's not washed. And I would ask you to look at the defense attorney's closing argument. And he talks about the condition of the victim and her clothing and how none of that is attributable to the defendant. That he was talking about the conditions she lived in. I would suggest they lived on a pig farm. I'm not trying to say anything that's derogatory towards people who live on farms or in rural areas. But if you look at his closing argument about the condition of those clothes, I would suggest to you that that would be one more thing he would look at and say, that could have been placed there at another time. There's no way to connect that to this particular incident, whereas the defendant is connected to it completely. It's his house, it's his bed, it's his employer, his employer's mother, and he's standing there naked, standing over the naked victim. I would suggest in this case it was perfectly appropriate for trial counsel not to go get that evidence and nail the coffin shot on his client. That's why it was appropriate for the denial of the motion previously that was affirmed by the single justice, which was a final and unappealable order. I'm happy to answer any other questions, and I apologize for going long. I'd ask you to affirm the Superior Court's order. Thank you.
Thank you very much. We'll take a brief recess.
SJC-11348, Commonwealth versus Stanley Donald.
Good morning, Your Honors.
Wait a minute.
Hold on just one moment. We want to get you live on tape, so, all right. Now.
Okay, good morning, Your Honors.
Yes.
My name is Tom Frothingham. I represent Stanley Donald. And Mr. Donald's motion for post-conviction DNA testing pursuant to 278A was denied, and it's the appellant's contention that it was denied in error, both procedurally and substantively. And briefly, I'd like to summarize the judge's ruling. The judge ruled that the motion did not comply with 3B and noted that the DNA testing was done and the results were admitted at trial. That was a response to a letter Mr. Donald had written to the court, and it had no reference to any test in it, and it clearly did not comply with 3B, and Mr. Donald never intended that to be a motion. While that was, I guess, being considered, there was a motion filed that went through the elements of Section 3B, and after Mr. Donald's, the denial of Mr. Donald's letter, which was mistakenly taken as a motion, then the first motion was denied, just citing back to the original denial. And I think it's important that there was no test requested initially. So there's no test under consideration by the court in that first denial. And the Commonwealth makes an argument that the judge's denial with her notation that it didn't comply with 3B and that DNA testing was done was a conclusion under Section 3B51 that the test was not undeveloped at the time of trial. So I would just like to point out that at the first initial ruling on this, there was no test requested. And I think that's important because I don't think in this process of evaluation under 3B, there was ever a consideration of whether the profiler plus co-filer test was different than the DQ alpha test that was used at trial.
It was first denied, it didn't comply with 3B, then there was a motion for reconsideration?
No, Mr. Donald had written a letter to the court. I didn't know about that or just wasn't paying attention to it, and I filed a motion on March 15th. He had written a letter shortly before 278A had been enacted. He had written regarding Senate Bill 753. So the court got that letter, then I filed my motion. Then the court said, taking his letter as a motion, denied it for failure to comply with 3B, and DNA testing had already been done. Then the court ruled on my motion and said, referred to the April 4th, 2012 ruling on Mr. Donald's letter. No more, just said denied under.
So in your motion, did you just said this wasn't available, is that right? The co-filer, profiler?
There was it wasn't very specific. There was a letter from a DNA expert who had been qualified in Massachusetts and appeared in one case, and that's in my brief. And he had written a letter in response to Mr. Donald's contacting him that there was the profiler plus co-filer test was newer than what was used at trial and was statistically more powerful than what was used at trial.
But you didn't really indicate that it wasn't available at the time of, the trial was in 99, right?
Yes, Your Honor. Yes, I argued that, well, there were the two provisions. Yes, I guess I don't know. I mean, I don't recall specifically. I thought the point of the argument was that it was a newer test and was not used at trial. I don't recall if I said specifically that it had not been developed.
But you do agree that it existed at the time of trial?
I can run through. I think it did exist, Your Honor, and there's a sort of a timeline reflected in the case law on the development of this type of testing. And Mr. Donald's test was conducted by Cellmark in either December 1998 or January 1999. The results were sent to the prosecutor in January of 1999. He was convicted in April of 99. In a case, there's a case Commonwealth v. Guy, 2009, which says that in May 2000, Maine laboratory began using the two newly available kits, Profiler plus Cofiler. So that's May 2000 is a year and a half after Mr. Donald's trial.
But there's actually, I mean, if you went back, there are cases that it's been used before that, I think.
I found several different DNA tests used, and this.
Well, in Colorado versus Schreck, the test used in January of 1999 was the test you're now talking about.
And yes,
and they said, well, in January of 99, it was relatively new to the market, but that was the test used in January of 1999 by Colorado Labs.
I think, Your Honor, in Schreck, there was that was a published case challenging the admissibility of that. So, and it was being used by I believe by the Colorado Labs, but had not been under the standard for admissibility of scientific tests, had not been confirmed to be admissible, and then someone was challenging its admissibility. I think it was found that it was admissible, but that's how new it was at that point.
But it used essentially the same methodology as the DQ alpha test, didn't it?
Well, you know, I don't know that, Your Honor. There's a PCR, polymerase chain reaction, which amplifies the DNA sample. So you can do these more sophisticated tests without exhausting the DNA sample, which I understand was true under the old RFLP format. But the fact that it's PCR, and then you've got the different, you could do it under DQ alpha, or that's certain loci, or you can do different testing. It's more loci, and it's different loci.
I mean, your
for
point
the test.
is that 13 loci is substantively different than 6.
That's exactly right. I mean, the whole point with DNA is how sophisticated you can make it. So you have. I mean, clearly, if you're looking at something different and you're looking at more loci, and this, I mean, the fact that the patent office allowed this test to be patented, I think it's clearly a different test than was done at trial. And it may have been, the case is referred to as being cutting edge or state of the art or relatively new to the market at about the time Mr. Donald went to trial. So, and then even if you conclude that this test was available at time of trial, then the next question for a hearing would be, was it admissible in the courts of Massachusetts? And we never got to that stage. And I would argue that in this case, all we need to do at the 3B stage is present information demonstrating those factors listed in 3B.
So is your thought that at this point there needs to be a hearing under 7?
Well, I think at a minimum, yes.
But I mean, is it also a maximum? I mean, why wouldn't it be a maximum as well?
You mean why
would we be in a position to order that the testing be done?
Oh, I see. Well, that's up to you. That's up to this court. I mean, I think that you could find the judge. She denied this. Actually, I think she denied it under. If you found that this was denied under Section 7, which I think you actually could find because of the ruling that the evidence presented at trial, exclusive of the DNA testing, was sufficient to deny Mr. Donald's trial.
Where does that fit into 7?
Well, if you look at, I mean, I don't think it does, but I think if you're looking at Section 7 and looking at this comparison between, well, I guess that would end up back with the judge to reconsider it if you found that she found that although this test was material to identification of the perpetrator, strictly based on looking at the test alone in the context of the facts of the case, it wouldn't make a difference. It was immaterial based on the facts presented at the case. I think if you found that, you would still send it back to her for a hearing. So I guess that's right.
Now, what do you understand the language of the statute to mean? The requested analysis had not yet been developed at the time of the conviction. You speak about admissibility, which I guess is a layering not mentioned in the statute, but apparently it was developed.
No, there's two sections. They're consecutive. The first one says, has it been developed? The second one says, is it admissible in the courts of the Commonwealth?
So in terms of developed, is the patent enough?
I would argue no, Your Honor, on that. I mean, I think even the fact that something's patented, in my brief, I give a brief example of that. The fact that something's patented doesn't mean it's available to the public. So I think just showing something is patented doesn't mean it's available.
So what?
think you would have-
So it must be more than developed at the time of the conviction. How do you say we should read that provision?
Develop, well, that's, I think the test would have to be shown to be used in some context or another. It would have to be shown to be a useful test. I mean, if you have something that it's say they use it and it fails, it has a high failure rate, so the test is not as patented. They patent it for a certain purpose. It's not useful for that purpose. I would say at that point, that test that's been patented is not available to the public. So I think you do have some overlap with the court's consideration of admissibility, just to determine whether or not the test is actually developed, useful, functional, and available to the public. I think you could, have a test that's not not readily available for use by the public, but you could still have it patented in some capacity or another.
Now, by your interpretation of the statute, you hope to be able to get this new profiler, co-filer test. 3 years from now, another test is developed, even better. You can come back and ask for that. 10 years later, a new test, you can ask for that?
Well, I think, Your Honor, under the statute as written, you have to determine whether or not it's material to the identification of the perpetrator of the crime. And if it is, and if it's a new test, and if it meets the other criteria, then I don't see that you can say no. I mean, that's exactly the position we're in now. I mean, I can't predict what will happen in the future. I think 10 years ago, people might have thought that this level of specificity in DNA testing was really a thing of the future, and now it's being used by condominium associations to identify members who don't pick up after their dogs. So it's now it's commonplace, but I think that if something better comes along in the future, meets the requirements of this statute, then you have to allow the test.
Okay, but it sounds as if you're saying once you get to 1 in a quadrillion, getting to 1 in 10 quadrillion may not be material. That at some point, you don't need new testing because you've already achieved a degree of accuracy and precision where something greater is not likely to be of any consequence.
I think, that's a good point. I think that if you're if you're in the quadrillions, you're clearly, that's not the case here, that we're in the thousands, but that's an issue I'm really not presented with. And in this case, I think that it's clear that the specificity of the testing under DQ alpha is far exceeded by the discrimination available under the profiler plus co-filer test. Just with regard to the provision that the court can dismiss this under Section 7 if the court finds there's some obstruction or delay. I know this was brought up by Justice Botsford earlier, but I'd like to point out that under the materiality decision is made up front on whether the test is material is made up front in Section 3. And once that is made, then under Section 7, I believe C, the judge, if necessary, can order discovery without consideration of the prima facie requirement of Rule 30. And I would suggest that that provision right there, with the way that's structured, it disallows a judge to balance the evidence, because it would be saying you have to make the decision under Rule 3 that it's material, and then allow discovery, and then once the discovery is made, then you decide the other evidence in the test, other evidence in the case will make that test irrelevant, and that it becomes immaterial. So I think that the way that's worded, I think that the idea of obstruction of justice has to be limited to specific findings. I don't know specifically what those would be. The judge made no findings like that in this case. The prosecution's argument was that the defendant was simply trying to obstruct or delay, which I would suggest was probably the same argument we made in many of the cases in which exoneration has been achieved through the Innocence Project.
So what do you think it means?
Well, I think maybe it was brought up before, if the defendant's somehow lying or falsifying evidence. something along those lines. I think that you might be able to find obstruction or delay. I also think that, just the fact that it's almost like obstruction or delay implies that you're impinging on the finality interest of the public, which the Commonwealth also raises. And cases have, well, my time's up. Do you mind if I just finish this one point?
Please do.
The case law has talked about finality as being an amalgam of interests: retribution, deterrence, the quality of the judgment, which might become worse over time as memories fade and witnesses are unavailable, and also the interests of the victims. And I would say that if all you're doing here is allowing a DNA test, that none of those interests, with the defendant in jail, retribution and deterrence are achieved. The quality of the judgment is not affected because we're dealing with something that you find under the statute has not degraded, that still has its evidentiary power, and the interests of the victims, there is no interest in incarcerating a person who is innocent. In any case, thank you very much, Your Honors.
Good morning. Good morning. May it please the Court. Hallie White-Spate, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. Your Honors, the defendant filed his original motion arguing that he was entitled to testing because the requested test, Profiler plus Co-Filer, had not been developed at the time of conviction. We can argue about what had not yet been developed means. My brother has proposed a number of alternatives, all of which I note involve reading a whole lot of words into the statute that are not there. Whatever had not yet been developed can mean. It cannot mean was used at trials happening before this defendant's conviction. Okay? And again, the date benchmark is significant too, because it had not been developed, not at the time of trial, not at the time the original testing was done, not at the time discovery was complete, but at the time of conviction. So April of 1999 is what we're talking about, and there are cases that refer to this test by its commercial name being used at trials in January of 1999.
Okay, so then I take it one would switch to whether it was ineffective. Is that what your argument is, that you would switch to ineffective assistance of counsel?
Well, that has not been raised. That claim that if this test was available...
If it's available, so you would hold this defense attorney to a very strict standard, I take it?
I think it's merely asking him to advance all reasonable grounds for the motion at the time that the motion is filed. We do that in all sorts of contexts, and I don't think it's unreasonable to ask a defendant to advance all possible grounds, when the grounds are limited and they're spelled out quite explicitly in the statute, to say, no, it wasn't developed, or if it was developed, then counsel was ineffective. He never did that. He also never made any claim that it wasn't admissible.
That isn't the ground on which the judge denied it anyway.
No.
So let's go to her grounds. Do you think it's permissible to say that the evidence was overwhelming?
That is not the ground on which the motion was denied.
It's one of them.
It is a side note, a comment appended to a ruling affirming and referring to the grounds advanced in the original ruling, which was that the defendant had DNA testing and the results admitted at trial. Now, this may not have the kind of precision that the court would like to see. She didn't say, I find that the test was done, that the test existed, that it was developed.
What do you say was the grounds on which she denied it?
That the test, he had failed to present information demonstrating that the test had not been developed.
And that's referring to the letter that he wrote?
The letter and the motion.
That's what you say Judge Kottmeyer found?
Yes.
Okay.
What language are you pointing to?
I note that in the appeals court decision, we find that DNA testing was done and the results admitted at trial. Now, that could also be read as ruling that the profiler plus co-filer test is not a new analysis within the meaning of the statute. The basic science underlying it is the same. It operates by PCR amplification and compares alleles at various loci. This one is improved simply because it can compare more loci than the other one.
Do you think that's a good reason to have testing or not? Or do you think that it would be appropriate to deny the motion because some DNA testing was done, just not this one, where the difference is more than twice as many loci?
The quantitative difference is large. I don't dispute that. I think given the way that analysis is defined in the statute, the process by which a forensic or scientific technique is applied to evidence or biological material to identify the perpetrator of a crime, I think that language suggests that new test not yet developed, means some kind of new scientific principle, which is absent here, and the defendant has made no claim that there is any new scientific principle at work. It's a refinement of the old test.
What do you say to your brother's statement that the letter that the defendant wrote never mentioned a test of any sort?
I think that letter is not a motion.
But the judge...
And if it is a motion, it clearly doesn't meet the requirements of Section 3 because it doesn't include an affidavit attesting to factual, which by the way, he has not provided an affidavit claiming factual innocence. All he says is, I have steadfastly maintained my innocence, which is
So the judge
not
then
the same.
couldn't have treated it as a motion?
She couldn't have, because it doesn't begin to meet the requirements of 3B. So at most that was sort of dismissed without prejudice. It doesn't matter because at virtually the same time, a motion which does include an affidavit and certainly asserts, makes an assertion for each requirement of Section 3B. And I think one issue before this court is exactly what the threshold showing has to be to get to a hearing. I can't see any reasonable way that we could claim this was denied under Section 7. It was clearly denied under Section 3B. But what is the threshold showing? Is it merely a burden of assertion, even where that assertion, as in the case of test not yet developed, is demonstrably false? Or is it, do you just have to say it? Or do you actually have to make some kind of factual showing? Because the defendant's factual showing here that the test had not been developed, it's the only ground he advances, is false. And just because there is no spaceship out there that uses the curvature of space to get into the cosmos doesn't mean that this test didn't already exist in commercial use at the time of his conviction. Now, briefly as to
Is that your standard?
Excuse me?
In terms of the meaning of being developed, you say the meaning should be in commercial use.
No, I think the patent, I think the allowance of the patent ought to be sufficient.
1994, if no test is anywhere, just the patent allowed, you'd say tough luck for you?
I think that means that the test exists. But even if that's not sufficient.
It's not commercially available?
The statute doesn't say commercially available. If the
What
legislature...
What use is it? If you can't get it, the fact that there's a patent, what possible use is that?
The legislature knew how to say available if it meant available. But the legislature said not yet developed. And even if this court wants to say we don't think it's just
any sense
to say just the allowance of the patent, the test is in use. It's in commercial use. It's commercially available. And not just some test using this technique, but the identical trademark that the defendant is asking for. It's being used at the time of his trial.
So now you've confused me. You say patent is enough, but the fact that it's commercially available matters. Are you saying that if it's not commercially available, it's still developed?
I'm saying the fact that it's commercially available puts us clearly over the not yet developed hurdle.
Okay, and my question to you is that the appropriate meaning of developed, or are you going to stick with your patent theory? That it may be developed by somebody, but no one really knows about it unless they go through the U.S. Patent Office and checks.
I think that the legislature, we should assume that the legislature meant what it said, and that if the legislature wanted to say was not yet commercially available, or was not yet the industry standard, was not yet in common use. And I would also note that under Section 3B5, among the reasons for the test not being done in the ineffective assistance section, does not require the defendant to state that his attorney knew about the test. All that's required is to say he knew that the evidence existed, and that's obviously a matter of the Commonwealth having complied with its discovery requirements, that the evidence existed and that the results of the test could be admissible and relevant. It doesn't actually require the attorney to have known about the test or that this specific test was out there. So I think that what the statute contemplates is new science that creates new possibilities, not merely more sophisticated versions of the old possibilities, including the possibilities not that were available and not used at trial, but used at trial and exploited by the defendant as a strategic and tactical matter. Because what we have in this case is a defense counsel who ably and vigorously and extensively cross-examined the Commonwealth's DNA expert on the number of men in the African-American population that could also have been contributors here. How many of those men live in the Northeast? How many live in the Commonwealth of Massachusetts? And then vigorously pressed this issue, the weakness of the Commonwealth's testing, in closing. He clearly made a strategic decision to rely on what he thought he could convince the jury was the weakness of this scientific evidence as a way of raising reasonable doubt.
Can I ask you this? The analysis that he's requesting, maybe there's a simple answer to this. Was it admissible at the time of trial in Massachusetts?
In Massachusetts, it's not clear. I couldn't find a case that discusses the admissibility of profiler plus co-filer at the time of the defendant's trial. I think had he been the first one to float that in a Daubert-Lanigan hearing, I think it would certainly easily have cleared the hurdle because it's not new science.
When was the first time was it Rozier? There was a case where it was recognized.
Well, it was in the case, I'm just blocking on the name, that where it was tested in the main lab. Guy, is that the one you mean? Guy?
Guy is not, I don't think Guy is about, yes, Guy does mention Profiler Plus.
Tested in
Guy
Maine.
is 2009. I couldn't tell you when the trial was.
Well, it was tested in 2000, and it said it was the main laboratory because ours weren't doing it.
Right.
And said it
which
was
is not required under the statute.
It was a relatively new test.
It was a relatively new test. Had he requested a Daubert-Lanigan hearing, I think he would easily have cleared the hurdle there.
So is that why we would deny it? Because he didn't request one?
Because as a strategic matter, he preferred to go with the testing that was done and present that to the jury. And objectively speaking, that was not unreasonable. And as for the overwhelming quality of the evidence, I just want to point out that what we have here is indeed overwhelming evidence.
But just point to me where that matters in this motion.
I think in this particular motion, in this particular case, it is relevant to, it would be relevant to a Section 7 determination.
Where in Section 7?
To the obstruction or delay element. That where the evidence was overwhelming, the testing would at most reveal a larger...
But on that ground, in almost every case, you could deny the testing, right?
No, I don't think so. I don't think so, because it's not a question of whether the evidence was sufficient to overcome a required
No,
finding
but I know,
motion.
but a lot
Obviously,
of cases have, I think, as has been argued, there are certainly a number of cases that was available to the legislature, at least as I read, in which you might say the evidence was overwhelming, and yet DNA testing showed that this defendant could not have committed the crime. That was before the legislature at the time, so I don't know whether it's appropriate to be looking at the strength of the case.
I think had the legislature intended that there be absolutely no consideration of the strength of the Commonwealth's case, of the nature, the quantity, the quality of the evidence at trial, of the trial tactics and strategies, they would not have provided that these motions should be heard where possible by the judge who presided at the original trial.
But if a guilty plea does not count.
There's a reason why a guilty plea doesn't count, because courts, and this court is no exception, are concerned about false confessions. And I think, I'm sorry, my time's up.
But please finish your thought, though.
My finishing thought is that the fact that the legislature expressly excluded those very narrow items, inculpatory statement to police, guilty plea, plea of nolo contendere, from consideration suggests that other evidence at trial may be in a limited fashion. Nobody is suggesting, despite what the amici argue, nobody is suggesting that the Rule 30 standard applies, and that kind of weighing happens. But if the legislature had meant this to be as purely mechanical as my brother says it is, any judge could hear it. In fact, you wouldn't even need a judge. It could be heard by a clerk.
Thank you very much.
Thank you.
Thank you.
Seney versus
All right, let's proceed. Good morning.
Good morning, Your Honors. May it please the Court, Sharon Sullivan Puccini for Dawn Morhy. Your Honor, I'm here today because we filed an application for further appellate review. Mrs. Morhy's appeal was dismissed as moot. There had been a harassment prevention order issued against her, and we filed a notice of appeal. During the time that we filed the notice of appeal, this court had, actually Justice Ireland had reported some questions on the constitutionality of the new statute, 258E, and Mrs. Morhy's appeal was stayed in the district court pending where the cases should lie. One of the questions had been, should the case go to the 211.3 route or to the appeals court as restraining order cases go. So by the time it reached the appeals court, in August of 2012, the appeals court rendered a decision called Lawrence v. Gauthier. And actually, you're going to hear a case after this case, one of the defendants in the Lawrence v. Gauthier case. And what the appeals court said in Lawrence v. Gauthier was that this court, in O'Brien v. Borowski, are treating harassment prevention order defendants differently than restraining order defendants. Specifically, if you look at the language in the decision, the words that are specifically important. First, it says, arguably, a wrongfully issued harassment prevention order poses the same concern for a defendant about collateral consequences as does a wrongfully issued abuse prevention order. And in addition, it seems that these cases present the same factual situation that, while likely to arise again, will evade review as each one-year order expires. Then, I think this is an important word, It said, nevertheless, the Supreme Judicial Court has reached a different conclusion about mootness in the context of harassment prevention orders. Then another two more important words are, therefore, it said that we are constrained, and I think that word's very important, constrained to dismiss each of these cases as moot. Now that's Lawrence v. Gauthier. In my case, which came out merely 2 months later, the court, it was a different panel, it was 128, and it dismissed the case as moot based on Lawrence v. Gauthier and your decision in O'Brien.
Did the appeals court vacate the order against you? Because
No.
in O'Brien versus Borowski, we did
Correct.
vacate the order against the defendant.
And I think that's an important distinction. Why did you do that in your case? And Your Honor, that was your case that you wrote.
I remember.
So what happened? Why it's distinct is that this court wanted to address the constitutionality, even though the orders had expired in O'Brien. But it also it went on to not only do that, but it went on to reach the merits. But it determined further factual findings would be needed to affirm the civil harassment order. So it went on to say that it was going to vacate the order. So in that situation, the defendant got the relief he sought, which has the order vacated. So there's also been, since we have filed our brief, another 128 that came out in the appeals court, and that case is Sousa versus Blumenthal. And in that case, they do the same thing. They say, this is just like O'Brien. We would need further, the case is moot because the orders have expired, but we're going to go on, and what they did was they said, in order for us to affirm it, we would have to have further findings, and at this point, to remand it, we're not going to do that. So we're just going to vacate it because it's like O'Brien. But the panels of the appeals court, what they're doing is they're treating them differently. That panel treated the case like O'Brien. My panel and the Lawrence case, which had a few other companion cases, they're just saying we're dismissing them as moot, that's it. And it's because we are constrained by the language by the SJC. What I've explained in my brief is that I think they're taking out of context what you said in O'Brien. Not only was it expired, they did go on to reach the merits in that case. And our position is that Mrs. Morhy, like other similarly situated defendants, should have that same right to have their cases reviewed. Now, this court has not had really a restraining order case in a long time. The case that the appeals court is where all the restraining order and harassment order cases are being decided. So your case, like back in 1995, was Frizzato. So the appeals court is now using Frizzato in other cases. And what it talks about is that in Frizzato, the defendant had argued that a defendant has a continuing stake in the appeal because 209A orders, they have adverse effects on future 209A orders and also bail proceedings. So when the defendant raised that in Frizzato, this court said that assertion had some merit. Now, cases after that, the appeals court has used the Frizzato language, and there's numerous cases that the appeals court has used to not found cases moot and go on to reach the merits. Those are Wildred v. Hickey, Utaro v. Utaro, Dolan v. Dolan, Smith v. Jones. And also, Smith v. Jones was in 2006. In that case, they said the same language as Frizzato, but they also added that a defendant has a surviving interest in establishing that orders were not lawfully issued against them, and it removes the stigma from the person's name and the records. Now, that is what we have here. Mrs. Morhy and other similarly situated defendants are not having their cases reviewed. They're just going to be called moot if the case does not get up there in time for the appeals to go through the whole process of ordering the transcripts, having the CDs. Every appeals court, clerk's office is different. Some, they do the tapes quickly, others take forever. Some clerk's offices don't assemble the records for months. So the timing for people to get up here, it just does not make sense.
So if an order expires,
correct,
and we review the what happened, one of the things that we could do is say, well, the evidence here is clearly not sufficient to support a 258E order. There may be other cases where we sort of scratch our head and say, gee, it's not really clear. The judge should make findings. Can we send it back for findings?
For my specific case, I also raised that the sufficiency of the evidence was not proper in this case, and you don't have to send it back.
But can we? Could we send it back? Could we send a case back for findings?
You have done, the appeals court has done that, but interestingly
So you
enough,
think it's okay to do that?
if necessary, because I think the interest is so great for someone to have, whether a restraining order or a harassment prevention order was legally issued properly is an important interest. And the public interest for why you should hear a moot case, especially Mrs. Morhy's case, is because it's a newly enacted statute. And when I had gone to file the notice of appeal, the clerk had said to me, everyone is filing these. People are coming in, they don't even know the names of the defendants. They're filing them all over the place, and that police officers are telling people, go down and get a harassment order. So there's so many going through the system. I think what's important, and if you look at specifically at Mrs. Morhy's case, the judge in this case kept cutting off the attorneys and saying, I'm not hearing the other two. I'm not hearing that. I only want to hear about the first instant. So, but under the statute, you need 3 or more acts of malicious
So if the judge was cutting people off, why shouldn't the case go back for a further hearing?
Because there was testimony about they did get all the testimony in about the 3 acts.
So he didn't cut them off.
He was cutting them off and saying, I'm only going to consider the first act. But they did get in all the evidence. And at the end, he focused on the first instant. In the end, the attorney for Mrs. Morhy says, Your Honor, there is not sufficient evidence on all 3 acts and on all the elements. The record is clear. They had attorneys, they had witnesses that got up. It's a complete record that you can look at each act and how it did not meet the standard for malicious cruelty behavior, and then how each element after that is just simply not met. So the point I guess I was trying to make was that it's important for the court, the appeals court, because that's where the cases will go, or eventually maybe the SJC, that cases be reviewed because it's a new statute and we need case law to develop. In O'Brien, Your Honor, Justice Gantz, you talked about Zulo, because another question that was before the court was where these appeals should go. So you talked about Zulo v. Gauguin, where the appeals had been going to the 211-3 route, but then they were going to the appeals court. And you said that the court said the policies of providing uniformity of treatment of litigants and the development of a consistent body of a law applies to 209A cases, and that's in Zulo, and that was cited in O'Brien. So we have the same situation that in O'Brien you saw that important concept that litigants should be treated equally. And as I was saying, in the appeals court, they're not even being treated equally because some of the cases are going on the merits and some are not. And if you get to the court faster and your case goes through the system faster, then maybe you will not have expired. The other important point is sometimes judges in the district court or superior court, instead of issuing an order for 1 year, they might only do it for 3 months or 6 months. And there's no way someone's going to be able to get up to the appeals court fast enough to go through that whole process. And if you wanted expiration of orders, I think a quicker route would have been 211-3, but that's not what the court ordered.
What about the merits here?
Okay, so getting to the merits, the 3 acts that Mr. Seney had alleged was that on April 15, 2011, and if I just say this situation was a fight on the field having to do with treatment at minor league baseball and the treatment of the children by the assistant coach. So Mr. Seney was the assistant coach of Dawn Morhy's son's team. Her husband was the head of the league. She didn't like what was going on with the way that the assistant coach had treated the children, swearing at them, using foul language. So she had, the first instance, April 15th, she had contacted the head coach. He had been on vacation. And of course, she has denied, but for purposes of appeal, he claims that Coach Robertson said that Mrs. Seney said that she was going to kick him in the knees and punch him in the face if her son was treated the way Mr. Seney had been treating the children on the field for minor league baseball. And these are elementary school children. The second incident is she had sent an email to Coach Robertson about the treatment of her son and her husband not being able to assist with the team. And Seney, actually in his affidavit, calls that that she was besmirking his reputation. And the third incident was April 17th, so it's like a Friday, Saturday, and then so the email comes. There's a conversation, an email she sends not to Seney but to the head coach, and then they're on the field having a baseball practice, and the coach is addressing the team, and Dawn goes over to the coach and starts saying, I want to talk to you about the way the kids are being treated on the field. And Seney comes over and realizes she's the one. He didn't even know who she was. He realizes she's the woman that sent the email and saying all these things. He says that she verbally attacked and threatened him. In his testimony, he never specifically says what she said at that third instant. So if we go back and if you look at each
So
of
there was
the
no
three,
evidence of a threat made on that third occasion?
on that third occasion, no. And what he keeps saying in his testimony is that she's ruining my reputation, she's damaging my name, and that's not what harassment prevention orders were established for. The legislative history shows that there was a high standard established, and I cite a law review article that has the legislative history in there, which says that we didn't want it to be neighbor against neighbor and people getting it for frivolous reasons, and that's what happened here. You need to have the conduct.
I take it your client got a restraining order against him.
Well, because he threatened to kill her at that third instant. There were mutual restraining orders. On that third instant, and she had a woman come in to testify that he was so upset about what was going on, he said to her that he was going to, you better not go out at night or I'm going to kill you. I will find you and kill you. So each of the...
And there were 3 instances of similar conduct?
That was only, and interesting enough, that was only the only act of supposedly he said it 3 times.
3 times in a single conversation?
Right.
Oh, okay.
So in other words...
So the judge here is trying to sort of resolve a baseball field and league dispute, and keeping these people away from
exactly. And what I also argue in my brief at the end is that if you look at what he says at the end, he basically says, you know, these are children that we're dealing with, and you're adults. You're supposed to be setting an example. So he was basically trying to say, you know, and I think he even says to them, move on. But that's not the reason that the statute was established. And if we allow people to just keep getting restraining orders and clogging up the courts and having people have these on their records, it's not what the legislature intended.
Thank you.
Thank you, Your Honor.
Good afternoon. May it please the Court, Kathleen McCarthy for Stephen Mastalerz. Your Honors, Mr. Mastalerz is up before you, and his procedural process by which he is up here is a little bit different than the prior litigant. At the time Mr. Mastalerz was litigating his appeal from the 258E, it really wasn't clear where to go. So Mr. Mastalerz did proceed in the appeals court just because of the body of law, Zulu, et cetera, that indicated that's where the litigants would go. And there was an inclination in the dictates that indicated that they would be treated similar to 209As. But out of an abundance of caution, we also filed a 211-3 up in the SJC. The 211-3 on August 17th of 2011 was denied by the single justice, and then we timely appealed it up to the full bench, which is why we're here today. As far as what happened in the appeals court is concerned, we did enter an appeal there. Also, it was stayed during the pendency of O'Brien and Borowski Borowski and O'Brien. However, after that opinion was issued, the appeals court simply dismissed the case as moot. Did recognize that in Borowski, Justice Gantz indicated that there is a similarity in the two processes and that they should be treated the same, but felt constrained by the language of Borowski to dismiss the case as moot. So really, Mr. Mastalerz has not had any adequate remedy to have his appeal heard. That's why we're here today.
Well, you couldn't, I mean, there was no application for further appellate review.
No, there was, and the reason for that, there was a motion to reconsider also filed in the appeals court asking that this case be distinguished from Borowski, and the reason that we put forward it's different from Borowski is because on this record we feel that there is enough for the court to read the record and determine, look, there wasn't enough and the 258E should not have issued, so in that sense they're in a different position. Frankly, because we were already up here under a 211.3, we did not do further appellate review because we were already up in the SJC. We had been litigating this thing to the best of our ability. We did receive notice to do a supplemental brief, and the issues we were directed to brief was whether the case is moot or not, and whether Mr. Mastalerz in the appeals court had an adequate remedy. And our position is he didn't, because he has not, despite his best efforts, been heard on the merits of his case. At the risk of repeating anything that my sister said, which was precisely on point, I would just like to point out that as far as the mootness issue is concerned, our position is that the case is not moot because the appeals court, in an abundance of case law, has indicated that a litigant or a defendant suffers collateral consequences from the issuance, the improper issuance of a restraining order 209A, and as Justice Gantz noticed in Borowski, that litigants are similarly situated, they have the same concerns, which is why litigants are using the same process to appeal to appeal rulings relative to 209As and 258Es in the appeals court. I would suggest that the concerns for 209A litigants are the same for 258E litigants, which are that if a restraining order is later vacated, that is good for a litigant as opposed to dismissed, because if a restraining order is vacated under 209A, I believe it's paragraph 3 or 7, that the district courts are instructed to destroy all records of it. And in the criminal histories board, which is very helpful, I do recognize that oftentimes the issuance, even if an order is vacated, they're not destroyed in the statewide domestic violence banks. However, I would suggest that it's very helpful to a litigant to have that type of information vacated and taken away from the criminal history of somebody. Also, with
where does the 258E order, where is it recorded?
258E order. Oh, I would say Corey in the criminal systems history board.
Unlike other civil orders?
That is my understanding, Your Honor. Yes, I think it does come up, and that's why there's a provision in 209A, I suggest, that improper vacated orders should be destroyed. There's no similar order if one just expires or if it's dismissed. So I do think that there is a strong interest in a defendant, for his name, his reputation, and whatnot, to be able to say, look, this is vacated, it was improperly issued, it didn't just expire, it wasn't dismissed from square one, it should not have been issued. Another area I think that I would like to address is the importance of having some guidance from the appellate courts as to what actually qualifies as civil harassment under the statute, whether it's a civil harassment, or what the court looks to for the stalking provision, or what other enumerated offensive can be considered in a 258E context. I would suggest that if orders are consistently not able to be reviewed because they have expired, that would create a situation where I suggest district court judges it would be much safer for them to just order the issue, because in all likelihood, there's not enough time for a litigant to get an order appealed within a year or 3 months or 4 months or 6 months to go through the process, so that the district court would not have the opportunity to get direction from the appellate courts as to what actually does constitute civil harassment. In Welch, we do have some guidance as far as 3 incidents, you need for civil harassment, but I would suggest that the other areas, there's I believe 5 areas that's ripe right now for case law to be developed, so that the judges can look at some type of case history to decide, yep, this is enough to issue the order, or yep, no, it isn't. I think it would have a chilling effect on litigants and defendants who believe that an order was improperly issued, if they're just going to be dismissed in the appeals court because they expire, then it's unlikely, I suggest, that a case would be, from the minute that the appeal enters, it would most likely take more than a year. I mean, most litigants in that context would oftentimes just walk away and not pursue appellate remedies because it would simply take too long and just wouldn't make sense. So for those reasons, Your Honor, I would point out that I don't think that because an order expires, it should necessarily be viewed as moot. In Frazato, as prior counsel indicated, the court has actually indicated that the fact that a restraining order can come up in a bail proceeding, that there is a strong interest in being able to see these things through and have some type of review. As far as how my case is different than Borowski, there are some areas. Oh, and one other thing, if I could backpedal for a minute, I would suggest I was also counsel on Sousa versus Blumenthal, and so I received notice of the Mr. Mastalerz case, who was a companion case to Gauthier, indicating that the appeal was dismissed as moot, which was disappointing. But then Mr. Blumenthal, who was in a very similar position because the order had expired, he did receive the benefit of having the order actually vacated, and it was just a few months later. So what we have now, the way the law is, or the way the appeals court is interpreting Borowski, they're not even interpreting it consistently, and there are being inconsistent opinions being issued from them, some of them saying dismissed as moot, others saying we're going to vacate it. So I do think it is an area that needs to be clarified from this court, so the appeals court will know exactly what to do with these types of cases. Moving to the merits of my case, first of all, Mr. Mastalerz, I would suggest, is in a little bit of a different position than Mr. Borowski, because on the record that was provided, and there were not written findings, but during the oral argument, the defendant, when the judge indicated that she was going to issue the order, the defendant said, I don't understand how you can issue this order. There were not 3 specific acts, and the judge specifically noted that there were 3 acts. She said, because I make a finding that the evidence was sufficient to show that there was more than 1 incident and that there were at least 3 in terms of cars passing by, and that she does remain in fear of continued harassment, that I will issue the order. So focusing just on that sentence, I suggest that is her findings, that what she's saying is a car that passed by the plaintiff's home. She's finding it was 3 times. I would suggest, if your honors look at the record from the hearing, there was testimony from the plaintiff that there was a car that went by the house. She believed it was the defendant's car, although it was different from the car that she knew that the defendant had. The car went down the street, according to her, shut off the lights, and then came back down the street again. My position is, and it's in the brief that was the primary brief, was that this was not 3 instances. This was just 1 time that a car went down the street and came back. And if the judge is relying on that 1 instance to allow the order, our position is that's incorrect, because going down the street, even shutting off the lights and coming back, does not make 3 instances of 3 or more acts that would constitute civil harassment.
There was evidence of other acts as well, though, however.
There were, but what I would like to point out to those, Justice Cordy, is the plaintiff indicated that the plaintiff and the defendant were roommates at one point.
Right.
The plaintiff said that at one time she saw the defendant handling her phone, and that was really all she said about that. So I would suggest that that would not meet the other criteria for harassment, and so cannot be counted toward the one of the 3. The other area that she got into in more depth was that the defendant allegedly hacked into her email, and that there was an email that was sent from her account, but from, I guess, the defendant's computer, that he improperly got into her email and sent an email to one of her friends. Again, I would suggest that the court, if they examine those 2 situations, those don't qualify under the other prongs of harassment that have to be met. For example, there's no indication of what the email that was sent from his computer, allegedly from her email account. There's no indication of what was said in that email. So I don't think that you can say that it was an act of abuse, or that it was sent with malicious intent, or that any other prong would have been met. Also, in that case, the email was sent to somebody else and not to the plaintiff. So I would suggest that it wasn't specifically sent to her and was not directed to her. So that takes that incident out of the box of being considered as one of the 3 instances of civil harassment. So in the handling of the phone, again, at one point she indicates one of her roommates saw the defendant handling her phone, doesn't say what was done with it. And again, I think that that does not necessarily qualify under the other standards for harassment. So if you examine the record, I suggest...
So you don't think that, you said that the courts need more guidance. You don't think that the O'Brien case provides enough guidance? Borowski?
Well, I think...
We decided that in January of 2012. When was your harassment hearing, back in 2010 or 11?
The harassment hearing was before that, yes, well before that. Honestly, I think that the kind of the word that's being tossed around and is causing a lot of confusion is the word moot. What does moot mean? And in order to ensure, I think, appropriate review by defendants, and so that everybody is kind of working off the same information and on the same page, that it would be helpful if what exactly moot means is expressed.
Thank you, counsel.
All right, thank you very much. All right.